Court, all rise. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston, within and for the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning. My name is Justice Walsh, and to my right is Justice Toone. To my left is Justice Tan. We are the three-member panel that will be hearing the 6 scheduled cases here. For the hearing date, and I will let you know that we intend on taking a break at the 3rd case. So we'll hear the first 3 cases, take a short recess most likely, and then go on to hear the next 3 cases. I want to remind those people who are here for arguments today, just the general rules, which many of you know, but each side is allotted 15 minutes. The timekeeper will start, and as the time goes down on the clock will go from green to yellow to red. And please ask everyone to be mindful and respectful of the time. If the panel has other questions at the end of the 15 minutes, certainly the panel members will ask those questions, but if please wrap up your argument in a timely way in accordance with that. There is no rebuttal at the appeals court, so your 15 minutes is yours to use, and use it wisely. I will just remind everyone that the panel has read everything, and so as far as best suggestion is really to get to the heart of your arguments, because the 15 minutes does go by quickly, and it's important that we hear the arguments that you believe are your strongest arguments before the court. Finally, I just ask that if you are here on an impounded matter, to please be mindful and ensure that those names or other identifying information that is impounded is respected. So with that, we'll begin our first case, which is Commonwealth versus CAGGIANO, if I pronounce that correctly, and Attorney Peterson.
May it please the court. Good morning, Your Honors. Jennifer Peterson on behalf of Peter CAGGIANO. If I may, I'd like to begin with my first argument regarding the denial of the motion for required finding of not guilty and to set aside the verdict. As Your Honors are aware, the prosecution in this case presented to the grand jury allegations that my client sexually assaulted his daughter. And specifically, it alleged 2 separate kinds of conduct, one involving finger and vagina and one involving tongue and anus. At the end of the presentation, it requested 2 indictments for aggravated rape of a child aggravated by age, and the jury came back and specifically asked, based on the evidence, why are you requesting 2 separate indictments for this sexual assault? And the Commonwealth specifically said, well, it's because each type of touching is a separate count. The touching of the vagina and the touching of the buttocks would be separate. And with that, it received 2 indictments, and it proceeded from there. Shortly before trial, which took place 5 years after the grand jury originally issued the indictment, a couple weeks before trial, defense counsel was notified that the theory was changing and that there was no longer going to be, the theory was penetration of the vagina with a finger and penetration of the vagina, not the buttocks, with the tongue. And it proceeded at trial under these 2 theories, and ultimately Mr. CAGGIANO was convicted of 2 separate crimes. And as Your Honors know, the brief says that, what we would argue here is that there was insufficient probable cause presented to the grand jury of these 2 separate crimes. We don't know, and we can't know, and we can't speculate that had the jurors heard that there were going to be 2 separate crimes based on 2 separate touchings. This is a single brief incident that was alleged to have taken place
Can I
one
ask
time.
you, how do you differentiate your case from the Clayton case?
The Clayton case, my understanding, involved one particular count. So they just changed. The Commonwealth said there was a sexual assault that took place. It was just a question of what the sexual assault involved. There was a single indictment. This case involves 2 indictments and 2 separate indictments for life felonies. And the Commonwealth, and tellingly, the grand jurors came back and asked why 2 indictments. And the Commonwealth said because there are 2 distinct touchings and these are the 2 distinct touchings.
So, first of all, the 2 indictments are verbatim identical, right? Just looking at the face of their indictment, you can't tell a single thing. And that does seem to be the only thing in the record that is offered by the Commonwealth distinguishing the 2, right? That comment. It is kind of ambiguous. The prosecutor says there's two touchings, and then he sort of, or I don't know if it's a he or she, but sort of.
She, I believe.
She, okay. So she says and kind of drifts off, and then says, that's why. So it doesn't seem clear to me, at least, that there was a clear delineation. One indictment's for this kind of touching, one indictment's for this kind of touching. It could have been sort of the prosecutor saying, well, these are different examples of things that would be actionable in separate indictments.
No, I disagree. I think the record was really clear before the grand jury, and the minutes are there for the court to review, that the Commonwealth was very particular, and also one of the things that was played was the complainant's SANE interview, and in that SANE interview, she specifically said that he put his finger in my vagina and he licked my butthole.
Yeah.
That was absolutely specific. And then when asked why 2 of the same, because we don't know if the grand jury, if there was 2 separate touchings of the vagina, if the grand jury would have agreed to issue 2 separate indictments for life felonies, or if it would have been one.
But one obvious problem is a child speaking, and anatomy references by the child aren't exactly clear as to what she meant at the time, right?
Well, I disagree, because she was very specific, and she actually used appropriate language. And I think, at trial, they said, well, I was kind of unclear about what was going on down there, is what I think she essentially said, what the complainant said. But that wasn't how it was at the SANE. And she was clear in her statements to the police. She was clear in her statements at the SANE. She was clear in her statements to her mother. She was clear across the board. And she had the right terminology, so she knew what a vagina was, and she knew where she was touched. So,
okay, so let's assume you're right and that there is a variance here, right? There is a variance between what the defendant was indicted on and what the jury found at trial. The standard under the case law and under Chapter 277-35 says the defendant shall not be acquitted on ground of variance between the allegations and proof if the essential elements of the crime are correctly stated, and I think they were here in the indictment, but unless he is thereby prejudiced in his defense. So what's the prejudice that you're pointing to?
I would disagree that we don't even get there, Your Honor, is what I'm suggesting, because it's not a variance, because there wasn't probable cause. We don't even
It's not a variance.
There's not a variance because there wasn't probable cause to even issue the indictment from ab initio. So our argument...
What is your argument then? What is your argument as to why?
Our argument is that indictment should have been vacated because there was no probable cause for that indictment as it was tried. They issued an indictment, and there wasn't evidence offered at trial to satisfy that indictment. So
is that what you were arguing? I thought you were arguing variance in your brief, that this was a variance.
I may have, but I would suggest, and I think my brief, if it isn't clear to the court, our position is that the Commonwealth should not have gotten that if this was the evidence.
When you say gotten that, do you mean the indictments?
The indictment should not have.
You're saying that the grand jury should not have even.
That we don't know if the grand jury, if the Commonwealth.
When you talk about probable cause, that's at the grand jury stage, right? Because that's the standard for indictment.
Yes, the grand jury properly indicted him based on the evidence offered by the Commonwealth.
Okay.
But the Commonwealth didn't prove that at trial.
Beyond
The
a reason.
Commonwealth sought to substitute a different crime, and we don't know if the jury would have indicted for 2 touchings of the vagina, as opposed to what the Commonwealth explained was each type of touching is a separate type. The touching of the vagina and the touching of the buttocks would be separate. That's what the Commonwealth told the grand jury. That's why the grand jury, presumably, issued 2 indictments as opposed to 1, because they specifically came back and said, why are you asking for 2 identical indictments?
Isn't that, though, variance? So I'm trying to understand best that I can your legal argument. It's that the trial evidence was different than the evidence presented to the grand jury that formed the basis of the indictment.
Yes.
And the Commonwealth's position is that the case law says, as Justice Toone had just reminded us, that so long as the essential elements can be met, that your burden is to show prejudice. Can we talk about prejudice for a moment?
Right, because your defense, or the defense at trial was that it never happened, right? And in
Yes.
fact, the defense counsel used the inconsistencies that we're talking about at cross-examination and at closing to try to discredit the victim, right?
So, but what would stop
Prejudice, I guess, if you can just address the prejudice issue.
The prejudice issue is the fact that Mr. Caggiano was indicted for 2 life felonies, but the Commonwealth wanted to substitute different acts that weren't presented to the grand jury as the acts for which he was ultimately convicted of. And what would stop the Commonwealth for asking for 3 or 4 indictments in front of the grand jury? The Commonwealth alleged a certain act, and that is the basis upon which it obtained the indictment. I would suggest that the Commonwealth did not prove what it said it was going to prove at trial, that the evidence that it gave to the grand jury. The evidence simply was not there. And there was a brief reference to totem pole evidence that the detective said, that the mother said, that the complainant said, that there was, and this is, the Commonwealth relies on this in their brief, that there was some, that the defendant supposedly, that the complainant had said that he touched, he put his hands in my underwear and touched my butthole in my private spot, and that was sufficient. But that was a one-off, and that was very, very different than the other testimony that was given, which she was very specific.
Can I ask you, when you boil down your argument, is your argument that the Commonwealth is bound to prove the facts at trial that they put into the grand jury?
I wouldn't say.
That's what I'm hearing. And I think legally that's incorrect.
When they're asking for multiple indictments for one incident, and the Commonwealth is doing that here, asking for multiple indictments for one particular issue, one particular incident, and they're parsing out different touchings that took place during that incident, I would suggest that yes, to call it a variance at trial and say that we don't have to, we can ask for as many. Maybe they could have asked for 4 or 5, maybe touching of the buttocks, touching of maybe some indecent A and Bs they could have requested an indictment for. We don't know how many they could ask for. Do they get the opportunity to ask the jury to issue indictments, especially indictments for felonies, and then just say it's a variance? And the difference between Clayton is Clayton was a single indictment for a sex crime, and they just changed the theory, and there was a variance. This is multiple.
One problem, this is a very challenging case to me. But one problem is that the indictments say the same thing, right?
Yes,
And
yes.
so you're making an argument that based on what the grand jury was told and what it understood, that one indictment was for a touching of the vagina, one was for a touching of the buttocks, right? It doesn't actually say that in the indictments themselves. And then they go to trial, and it's a jury trial on penetration by finger, penetration by tongue, right? And so it seems we have a leap here of sort of, we have to make an assumption that even though the indictments don't specify and the defendant didn't move for a bill of particulars, right, we have to make an assumption based on the grand jury transcript as to what each indictment pertained to. And that seems challenging to do, particularly since I don't know which one is which, right? I mean, how do we say indictment 1 was for this, indictment 2 was for that?
You do, because it's specifically set out, and we don't need a bill of particulars, because the prosecution specifically told grand jurors, I'm looking for an indictment for the penetration of the buttocks with the tongue, and I'm looking for an indictment for the touching of the vagina. The prosecution, we don't need a bill of particulars. We knew when time, place, manner, and means were all set forth right at the grand jury. And the Commonwealth...
That's in the grand jury transcript. It's not on any public-facing document that comes out from
the evidence at the grand... But those would be the grounds upon which the Commonwealth, suggested.
When does the defendant get access to the grand jury transcript in this process?
I'm uncertain, Your Honor. I wasn't
Okay.
trial counsel. But this happened, the change happened 5 years later, a couple weeks before trial. If I just may very quickly, Your Honor's closing arguments, the shifting of the burden of proof onto the defendant, the implicating his right to remain silent. Some of the statements, defense does not deny that this was his DNA. The defense's explanation defies common sense. Specifically, the Commonwealth argued that he failed to explain to jurors what he meant during a police interview where he said, I'm not saying she's lying. But what happened is they parsed this like quasi-admission. They parsed it because what he said is, I'm not saying she's lying, but I'm not saying it happened either. So they kept saying over and over again in their closing argument, I'm not saying she's lying. He didn't explain what he meant by that. So this implicates not only his right to remain silent, but also repeatedly shifted the burden of proof onto the defendant, and it did rise to the level of a substantial risk of miscarriage of justice, Your Honors. All right. Thank you.
Thank you. Attorney Cusick?
Good morning, Your Honors. May it please the Court, Tracy Cusick for the Commonwealth. Your Honor, the Commonwealth asks this Court to affirm the defendant's 2 convictions for rape of a child aggravated by age difference. Your Honors, looking at this Court has the grand jury transcript. What the Court doesn't have are the exhibits. Those were not before the trial judge when this issue was raised at the close of the evidence. The Court does not have the recording of the victim's statement or the recording of the defendant's full statement. A redacted version was admitted at trial, and that was not before the trial judge either. The Commonwealth did file a motion to transmit those if the Court wanted a more complete picture of what the grand jury presentation was. But, Your Honors, here I would suggest there is no variance. To the extent a variance could be perceived, it was not material. The evidence before the grand jury was a penetration with a finger, a penetration with the tongue. As my sister pointed out...
How do you know that? How do you know that's what he was indicted on? I mean, you can't tell that from the indictment. The indictments say the same thing. There's 2, they could be, carbon copies of each other, right? And so there's nothing about what kind of touching occurred for each one. How do we know what he was indicted of?
Your Honor, what we have is what was presented to the grand jury, and there was evidence of penetration with a finger, penetration with a tongue, and to the extent that when the prosecutor was asked by a grand juror which is which, why do we have 2 of these, the prosecutor alerted to the fact that it was separate acts and said one was for vagina, one was for buttocks.
Which is not what was the evidence at trial. It was both cases was vagina and different kinds of penetration, right? So why isn't that, at the very least, a variance?
Your Honor, I would suggest first where there were the different types of touching. When the prosecutor was responding to the grand juror, the prosecutor used the parts of the victim's body. There's different types of touching also based on the defendant's body, the finger and the tongue. And there was testimony before the grand jury, I believe it's page 45 of the record appendix, about the finger and about the mouth on buttocks and private spot. So there was evidence there.
No, I understand your argument that it was possible for the grand jury to have found probable cause on these two types of penetration, but how do we know what they actually indicted the defendant on? What do we have to go on other than the prosecutor's one statement where she mentioned the touching of the vagina and the touching of the buttocks? There's nothing else that we can possibly distinguish these two indictments on.
Well, Your Honors, first there's the separate touchings. There was separate touching with a finger and with the tongue. The indictments, both of them encompass natural and unnatural intercourse. They certainly encompass all types of conduct potentially at issue here. The evidence was sufficient before the grand jury for probable cause to issue these two indictments, and the defendant was on notice well in advance of trial. I don't know exactly when the grand jury minutes were provided to the defense, but the defense did have everything. There's no claim they didn't have it, and in fact skillfully used the difference between what the victim said to the prosecutor a few weeks before trial and what was put before the grand jury as to the penetration with the tongue.
Go ahead,
Yeah.
go ahead.
So, well, I think that the grand jury indictments were perhaps broad, right? They weren't specific to the crimes. Would you agree? They were, in essence, tracking the language of the law.
Yes, Your Honor.
Okay.
They were tracking
And-
the statutory
Right.
form, and neither one of them specified a specific theory.
So when we look at grand jury, we look to see whether probable cause exists to support the indictments, correct?
Yes.
Okay. And so in a hypothetical, if there was a crime, not this one, in which there were, as your sister has indicated, 10 or 12 instances of different types of rape, right? It could be one indictment with general language, right?
Yes, Your
And
Honor.
at trial, the Commonwealth could present evidence of any one or all of those 10 acts to sustain their burden, correct?
Yes, Your Honor.
So two different lenses. One is at the grand jury, probable cause, and did you establish probable cause for 2 counts of rape?
Yes, Your
right?
Honor.
And then after trial, the question is do you get to choose in some ways what evidence you put on as to the specific acts that the defendant is alleged to have committed? Right?
Yes, Your Honor. I guess with respect to get to choose, I guess the evidence is the evidence. And sometimes there may be, I'm thinking, unavailable witnesses or things that that the prosecution would like to present. I don't think that's an issue here, but yes, the Commonwealth could proceed on, in Your Honor's example, if there were 10 sexual assaults before the grand jury, could proceed with 1. And if there had been 1 indictment, it would be sufficient to proceed and prove 1 at trial, and that would be a conviction.
And there's a valve, right? There's a safety in that if the defense counsel believes there isn't probable cause, they can file a motion because they're given the grand jury testimony after indictment, correct?
Yes, Your Honor. The defense gets everything that was
Right.
before the grand jury.
And then later, they can file, so they can file pretrial to dismiss one of the indictments. And was that done here?
I don't believe so, Your Honor. I didn't specifically examine the record for that issue, but I don't believe that was done here.
Right. And then second is the issue of can the Commonwealth's evidence at trial vary to some degree from what was presented at the grand jury?
Yes, Your Honor, and the Commonwealth doesn't have to present exactly the same evidence. And again, dealing with people who might phrase things differently or might have a slight variance, and here it was a person who was 8 years old at the time of the offenses. She told the prosecutor that it was a penetration of the vagina. The prosecutor properly disclosed that to the defense, and the defense skillfully used that in cross-examination. Again, where the defense was, none of this happened, there could not have been any prejudice to the defendant. And again, there was evidence explaining the victim testified she didn't really understand her body at that point in time.
Can I ask you a hypothetical? The defendant's indicted on one charge, and it's like it is in this, but it specifies for a touching of the buttocks. Then there's a trial, and there's one charge, and the defendant's prosecuted for a touching the vagina. Is that allowable?
Your Honor, I think that's sort of the issue addressed in the Clayton case, where a particular type of sexual assault was alleged at grand jury, and the grand jury asked a question about, what about penis and vagina? And the detective said, no, that's not at issue here. And then at trial, the victim testified that that is indeed
Well, in
what
Clayton, I
happened.
think there was two different theories presented, and it didn't specify, and so, that's Barboza. I'm sorry. Go ahead. Oh, go ahead. So just finish.
Yes, Your Honor. I believe that in Clayton, it was, the grand jury was told that a particular type of conduct was not on the table, and then at trial, the victim testified as to that particular type of conduct, and that Clayton had an interesting history of back and forth, but the court ruled that that was okay, and that the Commonwealth could proceed with that evidence.
So just getting back to my example, if someone's indicted on conduct and then subsequently prosecuted for fundamentally different conduct, that's still that's a variance?
Well, I guess, Your Honor, fundamentally different. I mean, here it was an incident, everything.
It's the same incident, obviously,
It's
right?
the same incident, and I would suggest it's not fundamentally different. The indictment puts forth
the indictment specifies one kind of touching, and the defendant is convicted of a different kind of touching. That would be a variance, and then we look to whether there's prejudice?
It could be a variance, Your Honor. I guess it would depend specifically. I don't want to specifically say I'm not sure depending on the facts specifically, but in general, if there were multiple indictments and they alleged particular types of conduct, I think there'd be a much better argument for variance.
How often does the Commonwealth give indictments that are exactly the same like this?
I don't know, Your Honor. I mean, this is the indictments track the statutory language.
But why wouldn't the prosecutor and the government specify on each particular indictment, particularly where the grand juror, or at least one of the grand jurors, had this question, right? And I've seen grand jury indictments where there is specific language outlining, right, which act.
And that wasn't done here, Your Honor. That is correct. I mean, and again, it could have been if the prosecutor had specified penetration by finger, penetration by tongue, we wouldn't be here having this particular conversation. But I would suggest that we have what we have, and here...
But that's not a fatal flaw, in other words. So while you wouldn't be here, right? You'd be here for another case. But it's not a fatal flaw to have indictments that track the statutory language and aren't specific to the testimony at the grand jury.
Correct, Your Honor, and that is what happened here. And again, there was evidence before the grand jury. At least there's one statement in the minutes as to touching of private spot with tongue. So I would certainly suggest here that the defendant could not have been prejudiced by, to the extent that the differences, or even if it were to be characterized as a variance, which I suggest it is not, there was no prejudice here. His defense was, none of this happened. He did receive convictions on both. He did receive concurrent sentences. So in addition to no legal prejudice, he does have 2 convictions, but the reality is he's not serving additional time on the conviction for the second indictment.
And just so I understand, you argue it's not a variance because there was evidence presented to the grand jury that supported the charges for which he was convicted at trial.
No, Your Honor. I'm arguing it's not a variance because there was evidence of the penetration with the tongue, and whether it was the buttocks or the vagina, that that's not a variance. It's certainly encompassed by the language of the indictment, and that that would not be considered a variance. But if the court disagrees, and it is considered to be a variance, there's no prejudice here, and the defendant is not entitled to any relief on this. Your Honors, with respect to the closing argument, here there was the redacted interview of the defendant's statement to police was played to grand jurors. I did file that with the court. I assume it has made it to the panel, and that will be before the court. The defendant did speak to police. It was played for the jury, and the defense did ask the jury to carefully review that and to listen to what the defendant had said. Certainly it was proper for the prosecutor to also comment on the defendant's recorded interview with the police. And I would suggest there was no impropriety in anything the prosecutor said or did here.
Has the defendant responded to your motion or opposed your motion?
Your Honor, I think it's on the docket to be decided by the panel. I don't know what the defendant's position is. I know in other cases, I've never had anyone oppose one of these. It's just apparently the court rules require we do it that way. So the grand jury had the full interview. The trial jury had the redacted version of the interview. But I'd suggest there's no impropriety in the closing argument, and I would ask the court to affirm the 2 convictions. And if there were no further questions, I would rest on my brief.
All right, I see no further questions. Thank you. And just while the matter is still open, Attorney Peterson, do you have any objection to the Commonwealth's motion?
No, Your Honor, no objection.
Thank you. It was very well argued. The matter stands under advisement and is submitted.
Thank you, Your Honors.
All right, our next case is docket 25P0447, Commonwealth versus Hernandez. Good morning, counsel. I want to make sure I am pronouncing your name properly, so please correct me throughout this if I'm wrong, but especially on your name. Is it Attorney Streka?
Close, Your Honor. Shrika.
Okay. Welcome.
Good morning, members of the panel. May it please the court, Natalie Shrika, on behalf of Mr. Hernandez. The basis for the appeal here is the denial of Mr. Hernandez's motion to suppress. The motion judge first determined that the tip from a confidential informant regarding the transportation of narcotics from New York to Massachusetts in a particular vehicle described by the informant was sufficiently corroborated by independent police investigation. The judge's finding here was based on the fact that the lead investigator for the DEA task force was aware that this particular vehicle had been used in hand-to-hand street-level dealing. He made observations that Mr. Hernandez used the vehicle in a controlled buy on this one day prior to the arrest on February 25th, 2020, and that the law enforcement knew Mr. Hernandez lived in New York, kept the vehicle with him in New York, and that he had a suspended license. I would suggest to the court that the independent police corroboration was not sufficient. The judge also pairs this with the fact that officers observed Mr. Hernandez driving this vehicle on I-84 15 miles in Connecticut going towards the Massachusetts border, that he did in fact cross the Massachusetts border, and that those observations were sufficient to corroborate the tip. With respect to the information known to the officers, The record is entirely lacking as to whether the officers knew that Mr. Hernandez kept the vehicle with him in New York, or that the vehicle was in New York on February 25th, 2020, or any time in the preceding days that would suggest that the vehicle had transported drugs from New York to Massachusetts, consistent with the tip. There was testimony from Trooper Vitale, who is the lead investigator for the DEA task force. He was presented with a photo of the license plate for the vehicle in New York. He identified it as a photo from a license plate reader and indicated that it was parked on a street in New York. There was no testimony as to the time, date, location of that vehicle when that photo was taken. There was no testimony that the vehicle was in an area Mr. Hernandez was known to frequent in New York, that it was in connection with his address, or that Mr. Hernandez had ever been seen driving the vehicle in New York.
Can I ask a question? Separate from those arguments, which I understand them, if I'm driving down on a highway in Massachusetts and police query my plate and find that my license, the information that they have is that my license is suspended, and they pull me over, get my identification, my license is suspended, they have probable cause to arrest me?
Your Honor, I would suggest with those limited facts, I suppose they would. In this particular case...
Hoping you were going to say that they wouldn't arrest me, but go ahead.
Yes.
So how is that, in essence, how does that affect your argument if the police have probable cause to arrest your client, separate and apart from whether, and I'm not sure we know whether the informant was confidential or not, but we can put all that to the side for one moment to say if they have probable cause to arrest for a license suspension.
Yes, Your Honor. I would suggest in this case, they did not have probable cause to arrest based on the suspended license because of the CJIS, the Criminal Justice Information System report that was produced in response to Trooper Barrera's inquiry and the RMV information that Trooper Vitale had obtained a couple weeks prior when he conducted a preliminary stop of Mr. Hernandez. And the basis for that is that those two documents, the only information connecting Mr. Hernandez to the suspended license was a date of birth and a name. The RMV record had an address in New York, but it was not the address that Mr. Hernandez had on his New York driver's license and was otherwise not verified to be connected to Mr. Hernandez.
But that's the New York license, right? It's the Massachusetts license that was suspended.
So,
And they had just pulled him over, I think it was a couple of weeks ago when they conducted the controlled buys, right?
yes, Your Honor.
And so they stopped him, the police stopped him after observing the controlled buys, and they pulled him over, and he produced both, I think, the valid New York license as well as they discovered at that time they had the suspended license out of Massachusetts.
Yes, Your Honor. That is the course of events and how officers became aware of a suspended status. The issue really is that the RMV records and the CJIS query do not have any other identifying information for Mr. Hernandez. And so if he did in fact have a Massachusetts license that had been suspended, one would expect to see his license photo on those records. There was no photo. There was no height, there was no weight, there was no social security number, there was no address.
That a date of birth, right? And
Beyond a date of birth and a name, there was no other information that would connect this particular individual named HERIBERTO Hernandez to this suspension.
That's no different, though, than any other RMV or CJIS check, though, right? They don't pop up, but correct me if I'm wrong, with other identifying information that you're suggesting is the reason why the police didn't have probable cause. They get a name, and they get a date of birth, and they get an address, right? And the address didn't exactly match in New York, I understand that. But is his stop in CJIS and RMV query any different than others? Or
My recollection of just in my general experience is that other information would be produced. There were spots on the query from CJIS that had a space for the name and date of birth. And if all of that information is in the RMV records, which I believe is what CJIS is connected to, I would expect that all of that information would also be part of the report that's generated.
But I'm not sure why that adds to the probable cause calculus. In other words, it's not a question of it wasn't him driving the car, right? Because he's 6'3" and this individual is 5'2", right? You just had an experience a few weeks ago where he has a Mass license and a New York license, et cetera, and he's saying, oh, it's because I didn't pay a ticket, et cetera. So how does that detract from probable cause?
I understand the court's questions, and I think that really is what the heart of the issue is here, that how can these records be reliable when they do lack significant identifying information? And it is entirely possible that the HERIBERTO Hernandez, who has a suspended license with this particular license number, is the individual who produced a valid New York license, and that was the challenge at the motion to suppress, and is what the question before the court is today. So that really covers, I think, the second point of my brief. I would rely on my brief as well to explain that further, unless there are other questions about the license issue. With respect to the pretextual stop, I understand that was not raised by trial counsel at the motion to suppress. I would suggest to the court that the record is adequate to take up a review on the merits here, and to support a finding that there is a substantial risk of a miscarriage of justice, regardless of whether or not the stop was legal based on the suspended license. The conduct of the officers as they testified at the motion to suppress would suggest and support a finding that it was a pretextual stop in accordance with Ortiz. The facts there are
Very similar. Very similar, right? But here, as you started your argument, you conceded that it wasn't raised.
Yes, Your Honor, I do understand, and I'm happy to submit on my brief on that argument. I would just note that Ortiz does not require the officer on the stand to admit that the stop is pretextual, and otherwise I would submit on my brief on that argument. Going back to the confidential informant issue, again, I would suggest that the police corroboration was not sufficient. The motion judge relied on the fact that the officer knew all of this information about Mr. Hernandez and the vehicle prior to the February 25th, 2020 stop. But the fact that the vehicle was used in hand-to-hand drug transactions is not necessarily indicative or corroborative of the fact that the vehicle may be used in the transportation of drugs. They're not mutually exclusive, but they're also not mutually inclusive. And there was no other testimony to suggest that the officers had evidence independent of this informant statement that the vehicle had been used to transport drugs from New York to Massachusetts, or that, again, that it had even been in New York on that day.
Right, but they don't have to know that it was in New York specifically that day, right? They had information that this particular vehicle, and there's no question it was the same vehicle, they had the license plate number was the same, right? And that they had information from the second source, which again, we don't know if it was the same source or not, but I'm not sure that's material, right? That on this particular day, February 25th, I think it was, that the defendant would be driving the Trailblazer that would come from New York to Massachusetts, bringing in drugs, right? And then is it not enough the police, in fact, observed and spotted the same day the same car driven by the defendant into Massachusetts? Is that not sufficient?
My understanding from the testimony is that the informant did not specifically identify who would be driving the vehicle, only that the vehicle would be coming from New York, potentially on the 25th, potentially transporting drugs. And so the level of detail provided by the informant was not sufficient for the officers to observe that and therefore corroborate the informant's tip, as in other cases where informants provide quite a bit more detail, more information than just a singular incident. In many of the cases that I reviewed, they identify a specific person, they identify a specific time and place, they indicate what they believe is going to happen. And here, I think it would have been very material for the officers to confirm that the vehicle had either come from New York or had been in New York on or around the time of February 25th, 2020, in order to corroborate that significant component of the informant's tip. And if there are no further questions, I would submit on my brief.
All right. Thank you.
Thank you.
Attorney Rothkin.
Good morning. Emily Rothkin, Assistant Attorney General for the Commonwealth. May it please the Court. Where a prior investigation confirmed that the same individual in the same vehicle sold narcotics, the anonymous tip was sufficiently corroborated, as the motion judge correctly found. Similarly, where the arresting officer checked on his mobile terminal and confirmed the defendant had a suspended license in Massachusetts, again, as the motion judge correctly found, there was probable cause for arrest. Turning first to the anonymous tip, under Aguilar and Spinelli, the Commonwealth must show both the basis of knowledge and the veracity test. But deficiencies in either or both prongs may be made up with with police corroboration. And while we are examining an investigatory stop, only reasonable suspicion is required, which this court has noted is a less rigorous standard on both of these prongs. Here, every aspect of the tip was sufficiently corroborated. And the best source for the tip, I believe, is Record Appendix 119 and 123 to 124. We have a few pieces of information there. We have that a specific trailblazer would be traveling with specific drugs, fentanyl and heroin, from New York to central Massachusetts, and later that day. And that tip was given on February 25th, and about 10 days prior, on February 15th, each aspect of this tip was corroborated by the controlled purchase and further police surveillance. So we have that the officers saw, first, that same exact vehicle, same make, same model, same color, same license plate, H07, XHV, and they saw the defendant making a narcotic sale for the same type of narcotic, fentanyl. They continued to observe the defendant that day as he participated in several other likely narcotic sales, including at least one with one individual that the lead investigator of the DEA investigation knew to be involved with an ongoing drug distribution scheme. They took a photo of the defendant. They spoke to him later that day with an investigatory stop and saw his license, which showed a New York license and that he had an address residing in New York. Continued surveillance throughout that time showed that the car was parked around New York, which is something the motion judge also found in his opinion. And they also showed that surveillance showed that he went to Worcester several times, which is, of course, in Central Mass. And in fact, even on that February 15th date, later that same day, he was seen in Worcester. And so each aspect of this tip was corroborated by the police investigation.
So are you saying that the stop in Massachusetts could have been based purely on the reasonable suspicion that he was involved in drugs?
Not exactly. I think here what was important is the details of the tip was corroborated and specifically the action that morning. The tip said that morning that that same car would be driving from New York to central Massachusetts. And so when that same vehicle was seen that day driving, I do think it was an important component that he had to be, once he entered Massachusetts is when they stopped
Oh,
him.
he couldn't have been stopped in New York that morning? I guess and this may not be preserved, but I find this case awfully similar to Ortiz, right? And that's a case where, you find a technical violation to stop somebody because you want to investigate them for drugs, right? It seems very, very similar to this case. And I'm trying to disentangle what was the basis for it aside from, the issue of the suspended license in Massachusetts.
So I think one thing I obviously have a few arguments for you of
Sure,
why Ortiz is
go
different,
ahead.
which I'm happy to get into. But I think here what's a little confusing about this case, to my mind, is there's sort of two separate things going on, in that there was reasonable suspicion to stop the vehicle for an investigatory stop based off of this corroborated tip, but separately there was also probable cause to arrest him. And I think that brings us to what the key difference with Ortiz really is. And in Ortiz, we have that the officer was specifically told, stop this individual so we can search him for drugs. And that is what the officer testified to, is that absent the explicit instruction, he would not have stopped him otherwise. And we have that he actually followed him and waited until he changed lanes of the violation and then stopped him. So it has the facts, I think, are similar on the surface, but when you dig into it, there are a few more facts that point to...
Right, and there's no statement here by the officer, well, I did this on a pretext because I
Yes.
wanted to get for drugs, but you could certainly read that into what happened, right? That I assume our state troopers aren't just going through and doing license plate scans for suspended licenses when people go through Route 84. He did this deliberately, right? And it's because he was suspected of drug trafficking.
Well, we don't know from the testimony if it was because he had the drug aspect or if it was because he found out about the suspended license in Massachusetts. And I would say one of the other key facts that I think is quite different in Ortiz is the motion judge there, who was listening to all the facts and was closest to everything, decided the stop was pretextual. And that is the opposite situation we have here. The motion judge who was,
Well, it wasn't raised, so the judge couldn't permissibly come to that conclusion, right? So I'm curious because Justice Toone asked the exact same question I was going to ask you, and so this case is awfully similar in facts to Ortiz. And I understand your attempts to try and distinguish, and the police officer here didn't testify that he specifically was told to, but he was stopped and then arrested once they already knew that he had the suspended license out of Massachusetts, but then they arrested him, but then they called the canine unit in right away, right? And so who does that on a routine OAS?
And can I add? They towed it to the station for an inventory search, which for a typical operating suspension only.
Right. And yeah.
So a couple different responses, because I think there were a few different points covered, and hopefully I will cover them all. I think regarding the inventory search, I would point this court to the statute, which is General Laws, Chapter 90, Section 21, that they do have the right to arrest
No,
without...
it's not that they don't have a right, just like they didn't have a right. They had a right if somebody's changing lanes and doesn't signal to pull them over. The question is whether it's pretextual. And what are they really doing, and why are they pulling somebody over? And so when you look at that, it's not for the lens of, is there an inventory, and is it written, and can they have this broad power? Of course they can, right?
Right.
But is it pretextual? Does that add to pretext? In my view, sure does, because if I'm driving my car and for some reason my license is suspended, I don't think the dogs are coming out, and I don't think that my car is getting towed to the station and they're putting on the gloves and they're searching everything to protect my own belongings in the car.
Or even expect you're going to get arrested on a...
That too, but...
Well, regarding the dog sniff, there is the case Feyenoord, which is the case that examines the reasonableness, and one of the key, in that case, the officer just generally had a sense crime was afoot, and it was reasonable to call a canine to the scene because of the short amount of time it took. And we do have testimony here that it was about 5 minutes till the canine arrived, as well as testimony that the entire search from the time he first started speaking to the defendant until they brought the car back to the barracks was somewhere between 30 minutes to an hour. So it was a short time frame.
So to turn this analysis a little bit, do you think that in Ortiz, if there were findings that the police officer had reasonable suspicion to pull the car over for drug activity, that even if it was a pretextual stop, that would have been good enough? In other words, because part of your argument hinges upon, okay, well, they didn't raise it, so it's waived, but even if it's not waived, ours is different because we have both separate reasonable suspicion and we have a separate pocket of you're just under arrest because you drove with a license and you didn't raise this pretextual issue. But if Ortiz, can you answer that one, if Ortiz had reasonable suspicion?
I know I might be repeating myself a lot, but I do think that explicit instruction is pretty important because the fact that the officer had that explicit instruction meant there was no other possibility other than it was pretextual. Here, we do have this other possibility that it was for the probable cause to arrest for the suspended license. We don't know if the arresting officer would have ordinarily arrested, if he has a history of arresting.
Or called a canine unit to sniff the...
Yes, we don't know if that was something he did in every case. We don't have a lot of testimony about that because it wasn't developed at trial. And so I would suggest that when you look at the other cases like Rosario and Santiago and Buckley, and there are several unreported appeals court cases that also examine Ortiz, and those seem to really hinge upon this idea that based on the testimony, the sole purpose in Ortiz was only to do this other aspect. Here we do have testimony that that the arresting officer arrested him due to the suspended license and that the car was taken back to barracks for safety concerns. So we do have other evidence that there was at least a potential other reason here. And because of that the motion judge found that the arrest was proper, I think we're in quite a different position than Ortiz.
I guess I want to circle back, though. So is your position today here that, and again, all recognizing that this issue wasn't raised, that there was sufficient reasonable suspicion to stop the defendant here based on the information the police had?
Sorry, reasonable suspicion for the license aspect?
Based on the CI, the
CJIS.
anonymous source information, the drug activity.
Yes. So regarding stopping him, I think there was certainly reasonable suspicion in the Commonwealth's view for stopping him for the arresting officer in Massachusetts to stop him based on this anonymous tip. And I think that goes back to that police corroboration that the investigation showed each aspect of this was met. And I would point this court to the Ramon case where it says when every facet of the tip is corroborated that Aguilar and Spinelli is met. So I think on that basis there was reasonable suspicion to stop him. And I would also point the court to the fact that when the arresting officer stopped the defendant, they had a conversation and a couple of details were discussed. One was that the first thing he asked the defendant was, "Where are you going?" And he did say he was going to Worcester, which is in Central Mass. So we do have sort of even, that is obviously after the investigatory stop, but we do have further details that were corroborating the tip beyond that. And then, there was also the explanation for why the license was suspended, which I would suggest is, in addition to the CJIS report and the RMV check that was done in the mobile terminal, which confirmed the name and the birth date and showed, although not the same exact New York address, still showed a New York address, which is generally consistent with the fact that the defendant also had a New York valid license. And of course, he was sweating and shaking and things like that during it. So I think the Commonwealth's position is, first, there was reasonable suspicion to stop him, and that separately, that once the suspended license was confirmed, and the testimony at the motion to suppress showed that the arresting officer checked the suspended license twice, first when he got the tip to verify the tip from the lead investigator, and second after he had stopped the defendant.
So our analysis, would you agree, for reasonable suspicion must stop when the blue lights are turned on?
Absolutely.
Okay. And so you got a gray Trailblazer, you've got a time of day, and you've got a direction of travel,
Yes.
and you've got the prior controlled by.
Yes. And
Anything else that I'm missing?
I would only add that the controlled purchase was for the same type of drugs, which is for fentanyl, which was, the tip was heroin and fentanyl was what was purchased in the controlled purchase. But that is the only thing I would further add.
Okay, and that's reasonable suspicion to conduct a threshold inquiry
Yes.
and pull over the vehicle. Separate and apart from sweating, nervous, conversation, which happens after. Once the blue lights are on,
Yes.
that's where the analysis has to.
For the reasonable suspicion aspect of stopping for the investigatory stop, it must stop there.
Right.
For the second component of what happens afterwards for the arrest, I think those facts potentially could be helpful. But if there are no further questions, I will rest on my brief.
All right, thank you both.
you.
It was very helpful, and the matter stands submitted. So the next case that we'll be calling is docket 25 P210, Commonwealth versus AS. And this time we're beginning with Attorney McGrath, correct?
Your Honor.
Well, what time did you have to leave this morning from Western Massachusetts to
We are
arrive?
both taken care of extremely well. We are both put up in very nice hotels. Thank you very much for asking.
I want to say, as a Western Mass judge, welcome especially to the two of you. I'm looking forward to hearing both of your arguments.
Thank you so much for the warm welcome, Your Honors. Good morning. We know that this is a sealing petition, 100C, discretionary, second paragraph petition. We are arguing that it was improperly sealed. We really wanted to put this case up on the merits. We believe it's a good example of a serious case of a record of a pattern of recent dismissals of domestic abuse, and our substantive position is that it was an abuse of discretion to seal it prematurely. Our first position, though, is that the failure of the judge to explain his findings is the baseline abuse of discretion that prevents review on the merits, as explained by Commonwealth v. GF. So we're primarily asking you to find this lack of explicit written consideration on the arguments we raised was an abuse of discretion, and to remand with guidance for rehearing.
Okay, so what's wrong with the form after a hearing with, like a restraining order, check boxes that form the basis of the judge's findings?
This particular, I'm not familiar with that. Is that a balancing test? I'm sorry, I really have to.
That's okay.
Yeah, because I think that is actually the core of it. If it is a balancing test, then you would expect a judge to then consider the balance and then be able to understand that the check boxes are, to explain what in the balance of the good cause standard would have weight, which is also could be on a sliding scale, and that would default to an option, which is what we have here. We default to an open record. And it would appear, and I think there's actually, because we're really working on our face, we have no true explanation for what the judge was thinking on any of these factors.
Explain to me how you don't, though. And I ask this because the judge hears argument. The prima facie case is made. Both parties are there. Commonwealth agrees some things should be sealed because of time. Argument is made. Judge listens. Judge hears both sides. The judge goes back and makes findings on this form and checks off certain criteria, tracking the language upon, right? To say, sealing is appropriate in this case. And so the first question I have for you is, why is that not enough? I know your secondary argument is about why the judge got it wrong in this particular case, given the type of pattern of behavior. But, so tell me, what's missing that you believe isn't here
I think there are three types of issues. The first one is what we can see in the first factor of disadvantage, where there were affirmative facts that show that he was had 2 part-time jobs, so he had employment, he had gotten housing, and he was also in a certification program that would take 2 years to be
But
able.
that's the specific facts of why you disagree, right? But the first one is, you had an opportunity to be heard, the judge made findings, and you're saying that we can't tell from these findings whether the judge really heard me or not.
Yeah, it seems to me like you think the judge had to issue a decision as opposed to filling out the checkbox form. And if that's your position, I'd love to know why, because I'm sure our colleagues in the district court would not be thrilled to know they have to write decisions in each of these cases. So that's what I'm curious to.
I think actually the PON factor 3 is the best example of how the checkbox form is very confusing and really does need very specific unpacking. That is the, I'm sorry.
The disadvantage.
Whether the ceiling would alleviate the identified disadvantages, and that one actually has a variety of different types of disadvantages, so the checkbox form actually could go in different directions depending on the type of disadvantage that's identified.
What would you view in this particular set of facts? Would the judge have to find to satisfy your satisfaction of an explanation with respect to that particular prong, since you've mentioned that as?
Well, I think that we would want them to address the argument we raised, which is that that factor actually includes sort of a mini balancing test of, we need to say that the petitioner would benefit from this without a public safety issue. So we wanted him to address that because we thought that that is the actual issue that we find problematic.
So would he have to have said, because he filed an affidavit and he said, I'm trying to get back on my feet, I'm working with these different services, I have 2 part-time jobs, but that there are employers, and he acknowledged, because he couldn't seal everything, right? So he was still going to have some cases on his record, which I think can go either way in terms of this argument of harm and disadvantage, right? Because you're here appealing the judge's decision, saying, well, he hasn't shown, or at least the judge didn't find, and implicitly the defendant didn't show how he's disadvantaged. But I guess what would the...
I think there's a distinction here, and it's useful to unpack, which is we think that the judge could properly find against us, but it needs to be explained a little bit more when we raise an issue very specifically, that the argument that public safety is not implicated, because he actually didn't check that box. Public safety is not implicated in Section 3 and PON Factor 3.
It would be nice, and I guess it would be nice in a jury trial when the Commonwealth loses for the jury to say, we find the defendant not guilty because the Commonwealth didn't do X, Y, or Z. But in a jury trial, you don't get that, right?
Oh.
And in this case, let me just go back for a moment. This is a 100C applies to a very narrow set of circumstances in which cases are dismissed or null prost, correct?
Correct.
So in other instances in which there are guilty findings, for example, and time has passed, there is a provision of the law that allows automatic sealing, correct?
Correct.
Okay. No explanation, no nothing for guilty findings. And so we have this hearing, which you get an opportunity to be heard on a case that has been dismissed or null pros, where the judge makes findings. And so I can hear you on, we think we presented an argument that was worth being considered. Where is your evidence that it wasn't considered? Because I agree that an abuse of discretion would be like if a judge just didn't factor something in that was important and should be considered. But where is it that the judge didn't listen and, frankly, he just didn't agree?
It's a civil proceeding. Let's just start there.
Right.
Right. So we're not dealing with any, presumptions for the petitioner. The JF is what we think controls, and in JF, the court was explicitly required to address the arguments that the petitioner had raised.
But say, for example, stigma. The judge can take judicial notice that somebody with a record, I mean, we don't need specific evidence in 100C, do we, to require that the petitioner say, you know what, people look at me different now, and nobody will talk to me or have lunch with me because I have a null pros on my record, right? I mean, there's part of this which is a very practical application of some factors such as stigma that don't necessarily require anything but common sense and judicial notice of that people with a null pros or dismissal might have a disadvantage.
We're not arguing about that particular finding,
But
right?
but you're picking someone other, and my thought was interesting argument, legal argument about there's a specific category of crimes, domestic violence, that have a pattern of behavior that are so important to consider that we ought not seal, right? And then I thought, that's an interesting argument to be made. Well, what about assault with intent to rape? What about gun cases? What about all these others? And so the legislature didn't carve out an exception to domestic violence patterns and say 100C applies to all these cases, but there's a heightened burden here. And in a way, you're arguing that there is a additional kind of burden when there is a pattern, or should be a pattern, an additional burden when there's a pattern of domestic violence, that the judge ought to say, I need to explain this more because there's a pattern of domestic violence. Am I getting that wrong?
We are not looking for something categorical. We think in these cases, the standard needs to be applied with precision, with explanation, especially when we have identified 3 charges, 3 recent domestic abuse pattern of charges, and that time, which is usually the strongest measure of rehabilitation, 7 years for a felony, 3 years for a misdemeanor. We have a month out of rehab. We have less than a year since the last.
What would be in your mind an appropriate amount of time?
Well, it's a balancing test. So, like, if you can show enough rehabilitation or enough disadvantage, it could go a lot of different ways.
Okay, so understood that you think you had the winning argument, right? In that sense, in this specific case, that the 1 month wasn't enough. But you have to do more than that. You have to show that the judge abused his or her discretion, in this case, his, right? So your position is that the judge, and you want us to opine that Judge Pasquarello, in this case?
Yes.
Abused his discretion by granting the motion to seal, because despite other things that you're not arguing, changes, stigma, this and that, only a month happened, and that's just not enough time. You want us to say that that's an abuse of discretion. As a matter of law, just a month isn't enough time, and that the judge there's no reasonable alternatives. Is that what you want me to say?
We believe that JF controls. JF says that when issues have been raised and that this is a significantly interesting argument. It is an argument that needs to be considered. We raise some arguments that are not covered by PON. So all of the checklists are things that are considered by PON. PON does not address domestic violence, but it raises the issue of public safety 6 times. So essentially, because PON cannot consider all the factors that actually can be unpacked in this type of decision-making. When we raise a novel issue, it needs to be considered.
But it's a different, so you get 3 ceilings of shopliftings. Are you going to make this argument?
Absolutely not. Because
Okay.
domestic violence, we are allowed to consider the nature, of the offense. The nature of the offense, there's a lot of information about the nature of domestic abuse.
I'm not disagreeing with that, but what I'm disagreeing with in a sealed, a petition to seal a record on a dismissed or null prost matter, it does not appear that the legislature said, consider all these factors, but in domestic violence, put your finger on the scale and make it harder to seal. It may be that the judge wouldn't abuse his or her discretion if they said, given domestic violence patterns, 1 month is not enough to show extraordinary strides, the risk and public safety, etc. But it seems to me that by hearing and then filling out this form, the judge just ultimately disagreed with your argument in this particular case.
Well, clearly, the judge disagreed with our argument in this case, but we believe that JF requires more out of a judge. We believe that JF controls, and that when an issue is brought before the court, and there's actually there's a balance between two different opposing sides, he could disagree with us. We want to see our arguments considered. This is important. This is not just a checklist. It is actually a balancing test where the presumption...
Setting aside the procedure arguments, and you articulate them very clearly, you just have a substantive argument that the judge abuses discretion in not excluding these particular offenses, right? And so is that an argument that we can assess without sort of criticizing the level of detail? Can we just sort of say, well, the judge identified age of cases, and that factor doesn't really apply to the alleged incident that occurred a year prior, you seem to be suggesting that your procedural argument is all you're really advancing now, as opposed to sort of a straight up, the judge abused his discretion.
We think that it's really so much how the court would want to say, we believe that we can see an argument that would need to be developed. We're asking you, if you see that, please help set it up, because if it's not in PON, it's not in the checklist. Therefore, it's harder, I think, for the judges to consider these types of arguments.
What about box number 7, other factors to be considered at the hearing?
That's exactly what prevents a judge, from when after hearing evidence and saying, well, actually I agree or disagree, but here's why I disagree, and it's not specifically in the checklist, as Judge Walsh.
But the judge failed to do that. I mean, that doesn't actually help us in this case. I mean, it would help if a judge were conscientious and said, oh, this doesn't go in the PON factors, and I really do need to address this factor. So I agree. It's a little unclear how you would handle that. We're asking for some help for setting this up for rehearing. Oh my goodness, I am just about over time. Is there anything specifically you would, there is just one more thing. I want you to point out that what happens when a judge seals a record is they seal their own decision. It is the last document in a sealed docket. So it basically gets removed from public view. We really believe that in these circumstances, it's really important for this decision to be well thought out, because it actually removes the decision-making from the public view. We think that's part of why our courts and our system is set towards openness, and this interferes with that. And that would be my last point.
Thank you.
Thank you very much.
All right, how do you pronounce your last name so I make sure I do it right?
Mauer.
Attorney Mauer, welcome.
Thank you. Ann Mauer for AS. May it please the court, this court should affirm the decision below for 3 reasons. First, there was ample record evidence to support the judge's finding of good cause to seal. Second, his use of sound discretion was recorded in the form order, which is the equivalent of a written decision. And then third, the Commonwealth's arguments are policy arguments primarily about domestic violence cases, which simply are not supported by the facts that were developed in the record below. And for those reasons, this court should affirm the court's decision. I want to just jump right into the form, since there were a lot of questions about how the court can evaluate the judge's discretion here. My sister pointed to the third PON factor as evidence that the court did not consider their argument about public safety, but my position is that it in fact shows he did consider their argument about public safety. There are 4 check marks, or 5, including the other option. He did not check off no additional safety threat to the community. He did not find that we had shown that piece, but nonetheless found that the other factors, sub-factors of number 3 supported sealing. So he did consider the Commonwealth's arguments about public safety. He may have found them somewhat compelling, but found that the other sub-factors of 3 overwhelmed them, and so that sub-factor 3 actually supports sealing. And he did that with each and every factor that's listed here, which are the pond factors.
Hey, can I ask, it seems to me the most problematic part of this is the most recent charge involving domestic violence, which was on January 27th, 2023, about a year and a half before the defendant submitted this petition. And so when the judge writes in item 4, age of cases, that doesn't seem to be consistent with sealing a domestic violence charge that occurred a year and a half earlier. So how do we kind of reconcile that point with what we see on the judge's findings?
I think it's important to take 100C in the context of its companion 100A, which is automatic sealing for convictions. So on misdemeanor convictions, there is automatic sealing after 3 years with no discretion involved at all. So when we're talking about age of cases, at least for a misdemeanor, we're talking about a 3-year window where a petitioner can come in front of a judge and ask the judge to use their discretion to seal a null pros or a dismissal before that person is eligible for automatic sealing. It's 7 years on a felony. And so when you're talking about age of case, you're really talking about that window before you're eligible for automatic sealing. And Pond makes clear that the time that the judge should consider is the time from the offense date, not the date of the dismissal, although it's really up to the judge to whether they want to consider the date from the dismissal. But this was a 22 docket.
I mean, either way, though, the judge's role when considering whether to seal a particular offense is to look at the prior criminal activity. It's not about, well, this one just happened a month ago. It's looking back, right? So that if you had somebody who had criminal history in the 70s and 80s and had 30 years and now has a null pros or dismissal in 2022, factor number 4 is about the age and prior history of the criminal cases in context to this dismissal, correct?
Yes, it goes to rehabilitation, I think, overall. And, but you have to then weigh it with what efforts at rehabilitation the particular petitioner has shown. And here, AS has done quite a substantial amount of rehabilitation, especially in comparison to what his criminal history was. He's 52 years old at the time of the petition. He's making an extreme life change. He's in treatment for residential drug treatment for 18 months, and then he starts an addiction counseling program. He has his apartment that he's at on his own. He has these part-time jobs. His life is completely transformed. And at the time of the sealing hearing in July of 2024, he had been 2 years without an offense. So that's quite a lot of time given his history.
Do we know when the so-called batterers intervention program took place?
The date was not in the record.
Okay. Because I think the Commonwealth makes a good point. Well, is that recent? Is that in the past? If it's in the past, maybe it didn't work. If it's the recent, it's sort of putting that in context. And I think they also made an interesting point about anger management therapy not really being responsive necessarily to the threats that domestic violence pose. So I guess some of those, there definitely is good evidence of some rehabilitative measures here, but some of the points, the record seems a little bit unclear as to how this relates to the 3 charges at issue.
Well, I will say that in his affidavit, he specifically did state that while at ALC, the Alternative Living Center Rehabilitation Program, his efforts were not only focused on substance use, but also anger as it relates to his substance use. So there was a record that while he had completed batterers in the past, he was still working on those issues and had made efforts at those specific issues while he was in drug treatment.
I mean, I think the Commonwealth's point is well taken. I'll put it out there, that there is a presumption for transparency in public records, and there is a pattern of domestic violence, even with dismissals, particular to domestic violence, of null process or dismissals because of various factors that go into the crime of domestic violence and the many challenges, okay? But it appears to me that it boils down to, and it's an argument that I think is a worthy argument of, it's just too soon. Okay, he's done some things, but it's only been a month. The standard that we employ, though, is not whether if I were a district court judge, which I'm not, would I have sealed a record, right? It's that the judge abused his or her discretion by saying it's just too soon, given the type of pattern of behavior. I think it's a fair point, but tell me why the judge didn't abuse his discretion here.
Well, I mean, most importantly, because that's his discretion is to review all the facts and compare the time since the offense against the other factors in the pond test. And we can see how he did that based on the form order that he filled out.
So is it an abuse of discretion if the defendant gets a null pros yesterday and he comes before the court tomorrow, and that all these positives are there and the judge says, I'm going to seal the record? Is that an abuse of discretion?
Not if the record evidence supports that finding. I mean,
so in other words, number 4 isn't support. It's tomorrow. He gets an all pros yesterday, today he goes in to seal the record.
It could.
In the most efficient court in the Commonwealth, right? So if one of these factors doesn't appear to be met, then what happens? So we're talking about balancing. Yeah. So if you've got really strong 1, 2, and 3, but number 4, hey, this just happened yesterday. Can the judge seal that record?
Yes, the judge doesn't have to find every single factor. And in this case, he did, but he doesn't have to find each and every one. And I will say, specifically on that factor, because you can consider back to the date of the offense, the next day you might be able to show that factor nonetheless. Sometimes a case takes quite a long time to get to trial or to dismissal. And I just want to say, our position is not that the Commonwealth's policy arguments aren't, potentially valid, but there are 2 problems with them in this case. One is that the legislature did not include a special carve-out for domestic violence cases in 100C. They did in 100A when they said that violations of abuse prevention orders and harassment prevention orders should be on the felony time clock, even though they're misdemeanors. So they knew they had that option, and they chose to keep 100C a case-by-case analysis. And the Commonwealth is the only party here who knows why they dismissed these 3 cases that are in front of your honors today. They did not make a record that supported vacillation or recantation by this victim. Yes, there's a pattern, there's 3 cases, but there are plenty of survivors of domestic violence who are charged repeatedly with assaulting their abusers in retaliation, in a way to control them, and those cases get dismissed too. So if this court were to say, well, we have 3 dismissed cases, that's enough to sort of put our thumb on the scale, that would affect those survivors as well. So the Commonwealth did not vet their evidence in front of a jury. They chose to dismiss the cases, and they had an opportunity to say, this victim has recanted, or this victim does not want to proceed because she's in fear. They did not make that type of record.
In context, if they did make that record, and the defendant either pled guilty or was found guilty of some serious domestic violence 7, 8, 9, 10 years ago, automatic sealing, correct? So 100A and 100C read in context. Commonwealth can't do a thing, correct?
Correct.
When a defendant is absolutely a batterer and has pattern behavior and Commonwealth meets its burden by trial or admission, it's sealed, correct?
Correct.
Here, we don't have the findings. We don't have the time, but we don't have the findings because it's dismissed or null prost. And yet, the result would be that it would not be sealed if we accept the Commonwealth's argument, correct?
Correct, if I
So
understand
the
your question.
most serious cases in which the Commonwealth feels that a conviction is warranted, it's going to be sealed after a period of time. And C has to be read not in isolation, has to be read considering A as well.
Yes.
And so I think to some degree, when you're looking at C, it has to be looked in that context of these are dismissed and null pros cases.
Yes. And when you read Commonwealth versus Pond, the court is clear that it's the government, the state's interest is in sealing, because that is what creates public safety by allowing defendants to get back on their feet, find work, find housing. These offenses, once sealed, are not hidden from the police. They're not hidden from the DA's office. They're hidden from employers. They're hidden from housing providers. And, they're hidden from people who want to come in off the street and look at a court file. But this statute is meant to protect people with offenses that are dismissed so that they can go out and get jobs and find housing, not so that the police aren't going to know about him if he comes back up on their radar. All we're asking is that he has that opportunity to continue with his rehabilitation. And 100C and the judge below found that we met our burden. So for those reasons, unless the court has other questions.
All right, the matter stands submitted. Thank you both for coming. And as I said, the matter stands submitted. We'll take our mid-morning break now. Be back in about 15 minutes.
Court, all rise.
All right, good morning. We're back on the record with docket 25P0304, MONSIEUR TOUTON Selection of Massachusetts versus ABCC. And we have attorney, is it Segal?
Siegel, Your Honor.
Siegel. All right, good morning.
May it please the court, good morning. Joshua Siegel representing Monsieur TOUTON Selection of Massachusetts Limited. At issue in this appeal is whether the legislature, when it enacted Chapter 138, Section 18B, required the ABCC to revoke all licenses held by a licensee if the licensee held both a certificate of compliance under 18B and a wholesale license under Section 18. We submit that the legislature did not require such a result. It certainly permitted it, but the language at issue in Section 18B says violations of the provisions of this section shall be cause for the revocation of all certificates and licenses held by the certificate holder and his immediate family. Shall be cause does not require a result, it permits one.
Can I ask you, how would you distinguish the Cleary case?
The Cleary case, Cleary v. Cardullo is actually on point, I believe, Your Honor, on our side.
I'm sorry, yeah.
Cleary was a case with a very similar statute that says that holding, I think it was if the transferees were not disclosed, the ABCC shall have cause to either modify or revoke the license, and the court, the SJC, held in that case that revocation was permissive but not mandatory.
How do you explain the language in the use of may in the other parts of the, because the legislature obviously knows how to choose their word, well, arguably, right? May versus shall, and they chose shall.
They chose shall because. And there are a number of different ways to say similar things. What shall be caused at, so may is permissive, shall be caused is also permissive under general rules of English grammar. Shall do something is a directive. We see that in Section 25, where it says if you're on the delinquency list, the license shall be revoked until you're off the delinquency list, meaning you haven't paid your retailer hasn't paid their supplier timely. What this Section 18B language adds, though, is that at least at the time it was enacted, a licensee could have held other licenses that weren't involved in the 18B Section 18 relationship. At that time, and we addressed this in our reply brief, the licensee could also have held retail licenses, specifically off-premise retail licenses, package store licenses, effectively. And by putting this language in, it was saying the ABCC can revoke all licenses held by these licensees, licensee that held the 18B and the 18 license, including those package store licenses. Because what Section 23 says is that the license at issue is what the ABCC can address, can impose a penalty on. And so a violation of 18B shall be cause, if the ABC so exercises its discretion, to revoke all the licenses held by the licensee, which it did not otherwise have authority to do. And so that's what the language shall be cause does here, as opposed to say, it could have said may also. The legislature was not as precise as we would have hoped in the statutory language.
Well, my heart sinks as I say this, but I do feel like this case might come down to the standard review, right? Each side makes an argument, oh, this language unambiguously says X, and you say it unambiguously says not X, right? And the judge below said, well, it's ambiguous, it could mean either things, right? So I guess assuming that's true, and I know that's not your initial position, but assuming that we do find it's ambiguous, my question to you is, do we apply the standard Goldberg, used to be called Chevron analysis, where at step 2, we look to whether the agency's interpretation is reasonable, or do we apply some other test and just directly interpret the language ourselves, and why?
So you directly interpret the language yourself. There are cases, and I can pull the titles, I don't have them at hand, they're certainly in the briefs, that say that when the ABCC is interpreting language that does not involve their specialized knowledge or experience, no deference is given. And
But isn't that, so, okay, that's one reason to say that the Goldberg analysis doesn't apply. But that doesn't seem to be persuasive here. This is clearly, who else cares about this besides the ABCC, right? This is clearly matters within its province of determining how these different kinds of businesses interact in our three-tiered system. So do you have a different argument as to?
Well, so I would first point, I believe the case is Griffin's that I would say to for that language where it said transferring of a license. What does a transfer mean is not specialized knowledge to the ABCC. And even though who else transfers alcohol licenses but the ABCC, and so we don't defer to that.
Right.
But what I would say more to the point is that to exercise its discretion, the ABCC should have said it was exercising its discretion in interpreting the statute, should have identified it as ambiguous, and never did. In fact, it said to the contrary. It said that this language is a directive from, it's not so many words, it said is a directive from the legislature that we must revoke this license because anytime the legislature uses the word shall, we have to do what is being suggested. And that's just not simply reflected in the case law or English. And
it's just an assertion by the agency. There's no reason, determination, reason analysis. It's just sort of,
I think they said
the statute says this, and that's it, right?
Yes.
So that's not something we should defer to?
That's right, Your Honor.
But your argument doesn't hold water if we find that the 18B is clear and unambiguous and shall because, if we interpret shall because for the revocation, means exactly what it, that there's no discretion, right?
If you interpret shall because to just mean shall, then correct. If the legislature had said, if both licenses are held, the ABCC shall revoke all licenses, then this would be a different case. I wouldn't have an argument that the ABCC
Shall because
erred.
for the revocation is different than shall be revoked.
That's right. And the SJC addressed this in the Cleary versus Cardullo's case, where there was a similar argument made. Neighbors were challenging the granting of a license, or moving of a license, I believe it was, to a different location and new owner and in Cambridge, if I'm not mistaken. And the licensee's directors, I believe, were not properly disclosed to the ABCC, and at the time the statute said that failure to disclose the proper licenses shall be cause for the suspension or revocation of the license. And in Cleary, the SJC said this is permissive language, not mandatory language. That in Cleary, and it's on page 350, an error in the transfer application does not compel revocation or suspension, it merely authorizes such action. Now, there were two possible penalties there instead of one, and my brother says that that's a difference that matters here. It's the language that is really at issue is shall be cause. It shall be cause to punish. The ABCC did not punish in that situation, and the Supreme Judicial Court, when somebody came and said they should have punished, said, no. It's permissive, it's not mandatory.
So the commission says in response to your argument on Cleary that the disclosure requirement of that statute was a procedural requirement, not a direct affront to the regulatory scheme for alcohol, as is the case here. So what's your response to that?
That may be, I think it's a distinction without a difference here. What's at issue here is not the why, but what the statutory language says, whether the ABCC interpreted it properly. Shall be cause is permissive language. The SJC said as much. The Supreme Court has also said as much in different contexts, and the SJC has said as much also in the fair housing context, or implied in the fair housing context. The Supreme Court of the United States said it explicitly in the fair housing context, that shall be cause to revoke a lease does not require you to revoke a lease, it gives you grounds to revoke a lease. And this boils down to, frankly, language interpretation, statutory construction, regardless of the why. If we turn to the why, yes, there's a difference between the procedural requirements that were at issue in Cleary and the license holding requirements that are at issue here. They both reflect the role of the ABCC in regulating the alcoholic beverage industry, and reflect that this is in many ways a unique industry. It's the only industry that has two constitutional amendments about it, both prohibiting alcohol and then unprohibiting alcohol and reinstating alcohol. And all of these laws do arise from that context. When Prohibition ended in the 1930s, Many states imposed laws like this that allowed local regulation, statewide regulation and local regulation of various members in the industry that required wholesalers often to be locally owned businesses, although that requirement was recently struck down a few years ago by the Supreme Court, and imposed onerous regulations, I don't know if onerous is the right word, significant regulations on licensees, both in terms of telling the ABCC who owned the license. This was in response to the corruption that existed during Prohibition and before that allowed for intemperance and the overconsumption of alcohol that led to Prohibition. Then the crime that existed during the Prohibition period led to the repeal of Prohibition, so it could be a regulated industry. And all of it's important. Not having the tied house, not having wholesalers and suppliers and retailers all owned by the same entity was an important consideration. Now, it's been chipped away at. There's certainly licenses that allow, the local brew pub or local brewery, farmer brewery to wholesale its products and retail its products. Same with wineries, same with distilleries. We cite those statutes in our brief. And as an industry, it's heavily regulated. There are specific requirements imposed by the legislature. They change from time to time, but the language the legislature uses, the words the legislature uses, has to be given the meaning that it has.
But we don't just parse out one particular word. If there's ambiguity, we look at the whole, correct? And so I think your argument would be more convincing, perhaps, if it said, shall be cause for revocation or suspension or a fine or what have you, to give kind of a whole kind of menu of potential options that would suggest discretion and an interpretation that discretion rests to make that determination. We don't have to do this, but here are the types of sanctions that we can impose. Instead, it seems as if this is the whole kit and caboodle, right?
I disagree, Your Honor. Section 23, paragraph 5, gives that whole litany of things that can be done when there's a violation of the license at issue. So if you are let's stick with a bar, and you sell to a minor, that license can be suspended because you sold to a license. It can be revoked because you sold to a minor, and all of that is true. Here...
Right, sorry to interrupt, but the legislature specifically carved out 18B. It didn't just lump it in with all the other potential possible infractions, right? 18B shall be cause for revocation.
Of all licenses. That's what I was talking about before. That this language was not to say that you shall revoke the wholesale license and 18B certificate of compliance. It's that it allows the ABCC to impose, in fact, a broader penalty than Section 23 allowed. And that's, when you look at the entire statutory code together, that's where you find the true meaning of this additional language, because you couldn't have done that straight under 23.
So 18B came in with the 1971 amendment, is that right?
I believe that's right. I have
Okay, and before that, the statute did not contemplate wholesalers at all, and thus provided no mechanism for holding them accountable for violations?
No, Your Honor. No, that's not the point. Wholesalers were created, as far as I know, as far as I recall, with the 1934 enactment or 1933 enactment of the legislature.
So what did the 1971 amendment add? Was it applying to out-of-state wholesalers, or?
The 1971 amendment, it was was either Chapter 260 or 1022, and I can look quickly. At the time that this language was added in, adding this penalty into Section 18B. So I believe certificates of compliance were there as a way to regulate out-of-state suppliers. Certificate of compliance, if you take one step back.
Yeah.
The alcoholic beverage industry, there are 3 tiers, as it's called. The supplier tier, which creates the product. The wholesaler or distributor tier, which buys from the suppliers and sells to the retailers. And the retailers who sell to consumers either off-premise at a package store or on-premise at a bar or restaurant. And there were suppliers in-state and then suppliers from out-of-state. And so, lots of breweries, wineries, distilleries that exist out of states and are licensed in other states to supply their products. Section 18B allows those who are out of state that are suppliers to sell into Massachusetts and be regulated by the ABCC. And so what this language did, said, if you have that supplier tier license, an out-of-state supplier license, and an in-state wholesale license, and you hold them both at the same time, that is cause to revoke all licenses you have. At the time that statute was enacted, wholesalers in Massachusetts were also allowed to have package store licenses. So you could buy the product from wholesalers, transfer it to your retail license, sell it to your retail license, and then sell it to a consumer. I believe it was around 2010, the legislature changed that. I know I'm out of time, if I'd like to answer your question.
Keep going.
The ABCC changed that, the legislature changed that to say that you no longer could hold retail licenses and wholesale licenses. They've been thinking about it for a long time. We have the opinion of the justices case, I think from 1975, where the legislature asked the Supreme Judicial Court, is this allowed? It had been considered for a long time. It finally happened in 2010. They did not then go back to change 18B, but at the time that 18B was enacted, the wholesaler could also hold a retail license. So if I hold a retail license or another member of my family holds the retail license, which was I think a common occurrence probably, the ABCC was entitled to revoke all the licenses, entitled to, not had to, revoke all the licenses at that time. And that's what that language added when it was enacted in 1971.
All right.
Hearing no further questions, I rest my brief. Thank you.
Thank you. Attorney Marks.
Good morning or afternoon, morning, Your Honors. David Marks, Assistant Attorney General for the Alcoholic Beverages Control Commission. So I think we need to start at the beginning, which is the standard of review. There is no question that the standard of review here is that the court should grant considerable deference to the Commission's reasonable interpretation of the statute. And the way the SJC has articulated that, most recently in the 2024 S&H Independent Premium Brands case, is that the court should not supplant the interpretation of the Commission if the Commission's interpretation of the statute is reasonable. So the learned Superior Court Justice here did just that.
So she applied a kind of Goldberg-type analysis, right? Step one, is it ambiguous? She found it was, and I know you disagree with that. And step two, is the Commission's interpretation reasonable? That's like the standard Goldberg used to be called Chevron analysis, right?
And once she found it was reasonable,
right,
she
so
upheld it.
right, and that's a good position for you. But this is not a regulation that the Commission promulgated. It isn't even as your brother points out. It's just a statement. It's a statement in a enforcement decision, and that typically would not get the same kind of Chevron deference as a reasoned decision or a regulation might get, right? Is there a distinction there, or?
No, Your Honor. For example, the S&H independent case is clear that if the Commission is interpreting statutory language, that it has the authority to regulate, et cetera, administer, if its interpretation is reasonable, the court should not supplant it.
Regardless of whether it's a reasoned decision or just a statement.
Well, the question is whether the interpretation is reasonable. Here, the Commission plainly stated, we interpret Section 18B, this language in Section 18B, to be mandatory and not discretionary. It cited case law. It cited case law that says that the use of the word shall indicates mandatory. And so there's no question that here the Commission directly addressed this question. Did they write a 40-page brief on it? No. But they clearly did a reasoned analysis and said, this is how we interpret this language.
So you disagree with the very outset of the analysis, which is that statutory construction is de novo review? You're asking for some deference from some agency that's interpreting the law, right? Not a regulation of their own in area of expertise where we give deference, tax board, sex offender registry board, you know, what is alcohol or something of that nature. But just the general, very beginning principle of what did the legislature mean when they used this language? You disagree that that's de novo review?
Well,
Very first step?
I'm not sure what you mean by that. I mean,
Well, okay,
is the
let me
courts-
be specific. The language under 18B shall be of cause, or shall be cause, first block,
Right.
interpretation of the meaning of that portion of 18B. Standard of review?
There is no question that the court should engage in the question of what does this language mean.
Standard of review.
But the standard of review is that if the court determines that the commission's interpretation of this language is reasonable,
Disagree.
it should not supplant the commission's determination. That's what,
So I think it's de novo review. Tell me where this is wrong. We look at it, determine if it's ambiguous. If it's not ambiguous, reasonable or not, it is what it is. And then if there's ambiguity, then we consider at that stage some deference to the specific entity that is interpreting something that has, if arguably, something to do with their operations.
well,
Where-
again, I think that the standard is.
Well, do you agree with that? I mean, is that?
It's okay if you don't, but I just want to know if you do or you don't.
Well, I certainly agree that the court should determine whether the language is ambiguous or not. No question about that.
And assuming that we find it's ambiguous, next, then what's the next step?
If the commission's interpretation of the statute is reasonable, you should grant it considerable deference. And the way the SJC has articulated that is that the court should not supplant the commission's decision on that with its own view. So, as the Superior Court judge said, the plaintiff may have a perfectly reasonable interpretation of this language, but if the commission's interpretation is reasonable, then the commission's interpretation is entitled to deference and should be adopted. The reason here that the commission's interpretation is reasonable is multifold. First of all, the provision uses the language, the revocation of all licenses and certificates. There shall be cause for the revocation of all licenses and certificates if there's a violation of 18B, that is obtaining the license and certificate by the same licensee. That is to be distinguished from the legislature's consistent use of the word may when it intends to show discretion or give discretion to the commission throughout Chapter
Right.
138.
But here, as Justice Tan points out, you run into the Cleary decision, right? That's very similar language, and the SJC said, oh, that's discretionary, right?
That's right.
And then
So-
you also rely on Griffin's Brant Rock Package Store, which is a great name. But there, the language was much more, it was the commission shall suspend the license of the licensee, right? That would be great language for you here, and it's a step back from that, right?
Well, I have found myself calling this language hybrid, right? Yes, clearly if the...
Heightened? Did you say heightened?
Hybrid.
Hybrid.
So if the legislature says shall, as the Griffin's Brant case says, that's 99 times out of 100 directory, mandatory. If the legislature says may in Chapter 138, it grants the commission discretion. This is among the only situations where, in Chapter 138, the legislature has used the words shall be cause. Shall is an indication of mandatory. The reason this is different than Cleary is at least twofold. First of all, the statute in Cleary gave two alternative sections. By the way, the language has been amended. It doesn't exist in Chapter 138 anymore, but at the time, the language gave it two alternative sanctions. The misstatement in the application shall be cause for suspension or revocation. Well, both of them could not be mandatory. The reason it's discretionary is because it's giving the commission an option, one or the other. Here, in 18B, the legislature has used the term shall be cause to describe one sanction. That does not sound like discretion. It sounds like that is the sanction to be imposed, and the commission could reasonably believe that. The second reason Cleary is different is that in Cleary, the violation was considered de minimis. It was a mistake of fact in an application form, and the court did not read the provisions of revocation or suspension as a mandatory penalty for that violation, which it considered de minimis. Here, the violation goes directly to a primary purpose of the Alcoholic Beverages Control Commission, to prevent vertical integration in the distribution of alcoholic beverages. No matter how much the plaintiff says it's not an important purpose, the case law is clear.
Oh, well, it's clearly an important purpose. The 1971 amendment, that was designed to bring in out-of-state suppliers into the regulatory scheme. Is that right?
That's right. I used the title of the amendment to assist in the analysis. The title of the amendment was, if I can find it, an act prohibiting a foreign distiller from holding a wholesaler's license under the Alcoholic Beverages Controls laws. So 18B allows a foreign distiller to get a certificate of compliance so it can bring alcoholic beverages into the state, but 18B also prohibits a holder of a certificate of compliance from having a wholesaler's license in Massachusetts, because that directly undermines the prohibition on vertical integration. That would be both a manufacturer and a wholesaler holding, being represented in two tiers of the distribution system.
So here's a question. Interpreting shall be cause in 18B as mandating revocation, would that result in treating similarly situated wholesalers differently based on whether their suppliers are located in-state or out-of-state?
No.
Because you're mandating license revocation for in-state wholesalers with familial ties to out-of-state suppliers, while permitting more flexible remedies for comparable relationships involving in-state suppliers.
Well, the way the commission is reading...
Well, first of all, is that true? Is there a differential, am I right that there's a differential treatment here based on whether the supplier...
In terms of the sanction involved, the commission's interpretation treats everyone the same. There is no distinction.
But it's not mandatory for in-state suppliers in the sense that it is mandatory for out-of-state suppliers.
It's mandatory, period. The commission says that this language means that anyone who has a certificate of compliance and a wholesaler's license must lose both of them. We don't care where they come from, where they operate. If they have a certificate of compliance and a wholesaler's license, they lose them both, period. It doesn't matter.
State or out of state?
I'm sorry?
In-state or out-of-state?
Yes, absolutely.
Okay.
But that's
Absolutely.
their interpretation, correct?
Yes.
The difference being is that, couldn't you read the statute to only apply to the situation where there's an in-state and out-of-state?
No.
Why
No,
not?
No.
I know what you said, the commission is going to treat everyone the same.
No, in order to get a certificate of compliance, you need to be someone who imports beverages into the state from out of state. I don't think the certificate of compliance requires that the holder be either out of state or in state. It simply allows a supplier to bring alcoholic beverages from out of state into Massachusetts. But it prohibits that same supplier from then selling at wholesale alcoholic beverages in Massachusetts. So I think that the statute itself is agnostic about whether the person holding the certificate is out of state or in state. In fact, here, the entity that held the certificate of compliance was Monsieur Touton's venture, if you will, in New York. But it was owned by the same person. And that's what's important to the commission, to the statute. If it's the same owner, it's prohibited.
Right, but there's no evidence that Monsieur Touton in New York actually supplied any alcohol into Massachusetts, right? This is a very much of a technical violation.
Well, it's not technical in the least. I mean, it is a direct violation of the prohibition in Section 18. Thou shalt not have both of these things.
Yeah, but is there any reason for it? I mean,
There is no finding by the commission to what extent the certificate of compliance had been used by the time the case was presented to the commission.
If the commission had discretion, though, it probably would make that finding and make
Well,
a judgment as to whether or not this sanction was actually merited under the facts, right?
You might be right, Your Honor, absolutely. But at the time the case was presented to the commission, the plaintiff had already surrendered the certificate of compliance. So what really was at issue was the revocation of the wholesaler's license. But ultimately, even though the commission says it has the authority, there's no certificate to revoke because they had already surrendered it. But in terms of the extent to which the certificate had been used during the time Monsieur Toone had it, there was very little evidence on that, and the commission didn't make any findings on that, which I guess gets us just to the final point, which is...
One moment, please, too.
If...
All right, so I see that your time is up, and so we're going to have to rest in your brief.
I just wanted to say one thing about...
Okay, but I see that your time is up. I appreciate that, but you're going to have to rest in your brief. We're over the time.
I rest on my brief.
Thank you.
Thank you, Your Honor.
The next case is 25P0170, Maddalone Guy versus McCarthy. Good morning, counsel.
Good morning, Your Honors.
Still.
Kathleen Heyer on behalf of the plaintiffs and appellants Guy and Diane Maddalone. We're here today on my client's appeal from a number of decisions from the land court, which rendered a somewhat convoluted and confusing record for Your Honors. But the heart of the matter is my client's objection to the construction of their neighbor's new home on Nantucket which created, we maintained a new nonconformity in the side yard setback closest to my client's property, which has caused harm to them and was improperly authorized by the Nantucket Zoning Board through a special permit where a variance was required both under the terms of the local bylaw and the statute. My clients have maintained at all times since the complaint was filed that a variance was required because of the creation of the new nonconformity. I will note that we went into the trial of this matter with a fairly extensive set of agreed facts by both parties. There was really no dispute as to what physically was on the ground before the construction of the new home. There's no dispute as to what's on the ground physically after the construction of the new home. Everybody agrees on the dimensions. This really is more of a legal issue of the application of the bylaw and the law to the facts that the parties agreed to and the testimony that the judge heard at trial with respect to the use of the prior structures on the property which have since been demolished. We maintain that a variance was required for two reasons. First, because of the creation of the new nonconformity, the former home on the property complied with the eastern side yard setback, which is 2 feet under the local bylaw, and the new home does not comply with the side yard setback. It intrudes the side yard setback is supposed to be 10 feet and it's 7.8 feet from the main wall of the structure. There is a window well as well, which intrudes further into the side yard setback. We also objected to the land court's determination that the window well was not part of the formal structure. We also maintain that the project required a variance because the former home on the property lost its pre-existing non-conforming protected status as a result of 3 or more years of non-use of that structure as a dwelling unit. The evidence was quite clear that the property was not habitable. No one had lived there for at least 13 years.
That was not a requirement, though, right? Habitability is not a requirement for evidence of non-use, correct?
I would argue in this case it is, Your Honor, and that's because of the specific language of the Nantucket zoning bylaw, which defines a dwelling unit as a room or enclosed floor space used or to be used as a habitable unit for one family or household with facilities for sleeping, cooking, and sanitation. I know that the judge and my sister focused on the language to be used to argue that there's no habitability requirement, but we believe that that's incorrect because the definition itself includes a statement that it is to be a habitable unit with facilities for sleeping, cooking, and sanitation.
Whose burden is it to show with respect to the non-use? Is it?
I believe it's my client's burden to show that, Your Honor. And we did that, my clients purchased their property several years after Mr. Metz purchased his property. So when they moved in, they had a period of time with their reviewing the property and its use or lack thereof. But primarily, we relied upon the testimony of Mr. Metz and with respect to the non-use, and it was his property. And he testified that it was uninhabitable when he moved in. There's an agreed statement of fact that it couldn't have been lived in. He said multiple times that he bought it with no intention of moving his family in, that there weren't appliances in the structure, that all utilities had been cut off and at no point were they turned back on. And we believe that under the definition in the local bylaw, the lack of any appliances, the lack of any utilities, and frankly just the sheer condition of the home, which was, as Mr. Metz testified, a new home.
But there were efforts, correct, to market it. It was shown, it was staged in the period of time.
It was, Your Honor. So the testimony was that the real estate agent, Carolyn Duran, reached out to Mr. Metz because she was marketing what is now my client's property next door, and she thought it made sense to market the two of them together given the location and the real estate market on Nantucket. She had a single-year listing agreement with Mr. Metz. He testified that he wasn't particularly excited about selling it, but if the right offer came, he probably would have taken it. Mrs. Duran did show some people the property during 2015, but as of December 2015, her contract with Mr. Metz had lapsed. She testified that she received some unsolicited offers in later years, but Mr. Metz did not direct her to list the property. Mr. Metz made no efforts to market and try to sell the property. He sat back, and from our perspective, there's a difference between marketing the property and somebody contracting a realtor who had marketed it before saying, hey, is it still available for sale? We're interested in taking a look at it. I don't believe that rises to the same level of affirmative marketing and the same sort of affirmative steps. And that being said, I think there's also some question as to whether it was marketed as a habitable unit or as a complete tear down, which, given the condition of the property, Mr. Metz testified nobody could have moved in. So it's difficult to understand how it can be considered a habitable unit even if it had transferred to a new owner, that owner could not have moved into the property because of the state of the actual structure itself. And there was some evidence that there was efforts made on the exterior of the property. Vegetation was cut back. Mr. Metz testified that he and his family would walk down and enjoy the view from the property. But with all due respect to the land court judge, we don't think that shows use of the property as a residence. Most of the use of the property that Mr. Metz testified to could have been done without the house being on the property at all. He could go enjoy the view without having there be a residential structure there. He could use the garage to store his car and his bicycles without there being a residential structure there. And if there was not a residential structure existing, he would not have been able to construct the house that he has since constructed, because this is not a situation where the lot itself is non-conforming dimensionally. This is a fully conforming lot. Mr. Metz could have constructed a house that met the setbacks. There's plenty of space on the property for that. He only would have had to pull the house back a little bit in terms of design. Notwithstanding, he went ahead with constructing a home that is in the setback, although the judge did warn him that he was doing that at risk given the state of the appeal of the special permit. And as I argued in our papers, we believe that the judges looking at the test the judge came up with for non-use, I'm not sure it's even well-grounded in the case law, and as it was, we believe that he went on to improperly weight the outdoor activities over the interior condition of the house and the fact that it could not have been lived in at all.
Can I ask, this might be a stupid question, but say we were to rule for you, right? This new house is already constructed, right? So what would your remedy be if we were to conclude, well, it does violate the setback rule? The house would be torn down, or what are you hoping to achieve at this point?
I mean, that is a remedy, Your Honor. I recognize it's probably not the preferred remedy, given that there has been the construction of a new home on the property. That being said, I think my clients would be within their rights to request a tear-down order from the municipality, given the fact that Mr. Metz was warned that there was a possibility that if his permit was found to be improperly issued, that that was a potential outcome. That being said, as a practical matter, I think if Your Honor's ruled in my client's favor, I would somewhat expect Mr. Metz to go back to the town and seek additional relief, given that the structure has already been constructed. And I can't speculate as to what would happen in that instance, but I'm guessing that would be the next logical steps that the defendant would take.
I mean, your clients, I understand that they're upset about the setback, but there previously was an eyesore of a house that wasn't occupied generally, right? And now there's presumably a actual modern structure right there. And so I'm just trying to get the understand sort of the motivation here of kind of this pursuit of is this just, you know, bad ill will between neighbors, or is there really a concern about the encroachment? What's sort of the big problem now with where you are with
So my client's main objection to this was that the addition to the house that is in the setback, it's 2 stories and it's significantly larger mass than what was there before. And so if what had been proposed was simply attacking on the existing garage or something resembling the existing garage to a new house, with the 2 stories section being, you know, outside the setbacks and within the building envelope, I don't think we would be here today. It's the encroachment into the setback of the much larger structure and the conversion from the minimal accessory use in the setback to the principal use being in the setback that has impacted my clients. There are photographs in the record showing how the second story on the addition blocks my client's view to the west, and it's just, it significantly changes the feel of the neighborhood for them, living as close as they are. And it is noted in the record that my client's property is slightly into the setback as well. Most of the houses in that area are pre-existing non-conforming in some form, just given the era in which they were constructed. But in this particular case, my clients felt very strongly that having the addition of the second story with all that additional massing so close to their house, particularly where my client's house is what they call an upside-down house on Nantucket, where the living areas are on the second floor and the bedrooms are on the first floor. So when they're in the living room and the living areas on the second floor, they're now looking at the much larger structure that is impeding their view.
You had raised in your brief this interesting issue about whether Metz can expand the house on his property to take advantage of the reduced setback formerly enjoyed by the garage as a separate structure. And I think that's an interesting question, but was that clearly presented to the board or even the judge below, that issue?
I don't know that it was presented to the board, Your Honor. It was certainly presented to the judge. We raised it both at the complaint, all the way through the litigation. The parties filed summary judgment, which the judge denied the cross motions on summary judgment. We raised it there.
I didn't see the judge address it.
Or raise a trial, right?
It was raised at trial, and you'll see certainly the trial transcript indicates that I raised it and I argued it both in opening and closing, and our pretrial materials included it. The judge makes what I would suggest is a passing reference to it. The argument in, I believe it's the second opinion he issued, where he's discussing, he briefly just touches on our argument that there was a requirement for a variance. From our perspective, the judge pretty much firmly refused to engage with that issue, notwithstanding us putting it in front of him multiple times. And I don't know why that was. There is no appellate case law that I can find that is exactly on point. So it is a novel.
Kind of surprising there's not any case law on it. But I think this would be the first, you'd want to sort of in the first instance sort of present this to the board, who has expertise in this matter, and see what they think about, because they know the most about setbacks, right? And if it wasn't clearly presented to the board, is it preserved?
Well, to that, Your Honor, I would say that it was offered to the board during the remand, because this was an issue at trial, and we briefed it in the pretrial memorandum, and we discussed it at trial. And again, it's my argument on it is in the record in the closing argument. On the third day of the original trial, after which the land court issued its judgment remanding for determination, discussion of the dwelling unit, the to be used language, and also offer the zoning board an opportunity to make any additional finding of facts and request anything else it wanted on any of the issues that have been raised. And the board didn't even hold a public hearing. They just basically rubber stamped and sent it back up. I'm almost out of time, so if there's any other questions, I'll rest on my brief. Thank you.
I think it is now good afternoon,
Okay,
Your
good
Honors.
afternoon, you've got me.
Good afternoon, may it please the court. Andrea Perriner-Sweet on behalf of Michael Metz. We would suggest to the court that this court affirm the decision of the ZBA and then as affirmed by the land court that a variance was not necessary in this case and that it was well within the ZBA to determine and decide that a variance wasn't needed and that only a special permit was needed. I think we all agree with you, Justice Toone, that this is a very novel issue in terms of, determining whether you can aggregate two structures in terms of setbacks.
I'm kind of quite surprised that there doesn't seem to be case law on it because it seems very fundamental to being a homeowner in Massachusetts that you might have a setback for your garage and a setback for your house, and can you combine the two and sort of expend? People would have tried this before if it were clearly.
Well, people may have, and there may be decisions out there at various local zoning boards, but obviously it has never gotten to an appellate state and status for this court to review. But what I would suggest, Your Honor, is that the Nantucket ZBA is the agency, the authority that is best able to interpret its own bylaws in this matter. And they looked at this, and they did have a public hearing on this, and they understood and saw that the garage was 0.2 feet from the front setback when a 10-foot setback is needed. And then the garage was 7.8 feet from the side yard setback. Admittedly, the house, the separate structure for the house, fell within the appropriate setbacks, so there's no dispute about that. But I think I would suggest sort of for the court the following scenario. Imagine for a minute we start with the two structures where they're located. And sort of the first request is, can we move the garage back from the street level just into the property, and say we move it into the property and we attach it to the house. At that point, you haven't changed anything. The garage is still 7.8 feet from the side yard setback, and nothing has changed. And I would suggest at that point, no variance is needed. Then maybe the next step is, I think we'll add a second story to the garage. Again, staying within the footprint of the garage, it's still 7.8 feet from the side yard setback, but we're now adding a second story. And I would suggest again, Your Honor, that under the zoning bylaw, and I think it's 139, section 33A1, I know it's 139-33, I might have the other one's wrong. But a pre-existing non-conforming structure, which is what this garage was, could be extended or altered or changed, and I'm paraphrasing. It shall not be, a variance shall not be necessary unless it is substantially detrimental to the neighborhood or the setback is made more non-conforming. So I would suggest, Your Honor, that the ZBA rightly decided that the second story that was added to the garage, that was moved back and attached to the house, was indeed appropriate for a special permit. You never went over the 7.8 feet. You're in compliance with that particular zoning bylaw section, and you have still a non-conforming, I agree, a non-conforming structure, but you haven't created a new nonconformity, which is what is necessary for a variance.
Did the ZBA ever address this issue directly and kind of get to the heart of whether you can combine setbacks or with having separate structures and setbacks and say, we're going to put them all together and turn the garage into a spa, make it two stories or whatever. I mean, was this issue teed up to them, and was it?
Whether it was teed up exactly like that, I don't know, Your Honor. But we have the ZBA decision, and the ZBA decision, I would suggest, really doesn't address it. I would agree with you, doesn't address it head on. But I would suggest that There must have been some consideration because they recognized that and allowed a special permit for this construction. And I would suggest if they thought that a variance was necessary, that they would have said that to the applicant at the time and told the applicant at that time, you need a variance, you need to come back and ask for a variance. And there's nothing in the record that suggests that that happened at all, Your Honor. So I would suggest, Your Honor, that while, there was no nonconformity, that everything is still within 7.8 feet from the Maddalone's property, and that the Metzes did what they were entitled to do, the ZBA did it correctly, and Judge Vey correctly found that the special permit was all that was necessary. The other issue that my sister has raised is the issue of non-use. And again, the case law and certainly the bylaw, as Justice Tan pointed out, doesn't just say that the dwelling has to be occupied. It's either used or to be used. And I would suggest that there's nothing in the record that ever suggests that this home could not be used as a dwelling unit, simply because it may not be habitable at a certain point in time doesn't mean that at a future point in time, it could be habitable with renovations, such as renovations that happened here.
It's intuitively a little surprising that someone owns a beachside house in Nantucket and never lives there. I understand that Mr. Metz got his bike out of the garage, and they fixed the septic system up, and they did some landscaping, but didn't sound like he ever or his family ever lived there.
He had another home there, Your Honor. So
oh, okay.
He was living in the other home where that he had there. So he
never rented it out. Never sort of let friends stay there. There's no one ever lived there. Right.
That is true. Well, I should
up until a certain point, right?
I mean, yes. Yeah. There is testimony and in the record that the house, and this was before Mr. Metz did own it, was rented out up until I think 1998. So. It was for a while habitable and rented out. But again, Your Honor, he owns a home that is subject to the HDC, the Historical District Commission, that they have to approve any sort of renovations or even demolition of the building. When he initially bought the home, he did explore, at least initially, what could be done. At that point, he, for whatever reasons, determined not to do anything. But from the time that he purchased the property, he did maintain it, okay? He made sure it was safe. He made sure it was secure. He did landscaping. He and his family would walk over. They used the garage to store their bicycles. There were some renovations done. He had a caretaker who, propped up the porch and who repaired storm windows. When the dwelling was put on the market by Mrs. Durand, there was a cleanup of the house. She staged it. You have the photos. I think there's a video that's also in the record that you have where she staged the house at that point in time. I do think that it is irrelevant and a red herring that Mr. Metz did not accept any offer that may have come in on the property. We don't know why. Maybe he didn't like the purchase price. We don't know why, but I think that that's a red herring. I think what's more important is that it was listed in 2015. Ms. Durand continued to have a key to the property with Mr. Metz's permission to show the property during 2016, 17, 18, and 19, which she did several times a year. Again, in I think it was either 2019 or 2020, I can't remember quite off the top of my head, but there was an offer made on the property which Mr. Metz declined. Again, we don't know why, but he did decline. So that property was being marketed as a single dwelling home during that time.
Can I ask a different question?
Sure. Of course.
Thank you. And I, please correct me if I have this wrong. If there was no garage, your hypothetical got me thinking quite a bit. And there was no garage, because the basis of this controversy appears to be the height, the size of the home, correct? In the height, in the now kind of changed view of what is seen. But if there were no garage and just the home in whatever state it was, could your client tear it down and build a two-story large building?
It kind of depends, Your Honor. So first of all, it was subject to the Historic District Commission, so let's assume that he gets, if in your hypothetical, we want to assume that he gets permission to do that, or gets approval from the Historical District Commission to build whatever you're suggesting. That would be the first step. If, and agreed, the house did not at that point in time encroach into the side yard.
Right.
If he put a second story on the house, okay, still not encroaching in the setback, then yes, Your Honor, I do believe he could do that. It would be up to the ZBA to determine whether it was substantially more detrimental to the neighborhood or not. And I would also suggest, Your Honor, if I could,
No, please.
is that adding second stories to these homes in the Surfside neighborhood of Nantucket is done all the time. If you look at the statement of agreed facts, I think it's like paragraph 83 to 104, there's a whole list of homes within the Surfside neighborhood where second stories have been added, where there's been some encroachment into the side yard setbacks. So it's not unusual in this neighborhood that would happen.
And I guess the question, is the zoning board, whether it be a special permit or a variance, right?
I would agree with that, Your Honor.
Okay, thank you.
Can you go back to, I'm sorry, just the non-use, because I know you were just talking about that previously, and the other side points to the fact that, there was testimony at trial from Mr. Metz, actually, that there were no appliances, nobody could live there, no utilities, everything had been shut off, and is that material,
Well, I think, I don't think so. First of all, the utilities were shut off, according to Mr. Metz's testimony, but they were there, okay? I mean, the power lines went to the house, so they could have been turned on whenever Mr. Metz wanted. They're also, same with the water. The water could have been turned on. So all of that is there. And the other thing, when you look at the bylaw and it talks about sanitation, he put a septic system in 2009 and 2010. I would suggest that, a septic system goes to the sanitation of the house and how you, keep your refuse, shall we say, properly contained and maintained. So I would suggest, Your Honor, that that's in and of itself would not simply go to non-use. I think when you look at what he did in the context of, a home that, was in disrepair, we can't, deny that, that he did what was appropriate and necessary to keep it in a manner that, as I said, was safe, was secure, that could be sold or marketed, that ultimately was sold, obviously, at some point in time. And so I think that the Judge Vey got it correct when he determined that the property did not suffer from non-use. And the other thing I would suggest, Your Honor, is, Judge Vey was the finder of fact on this. And, while my sister has argued in her brief that he may have put more weight on certain factors than other factors, I would suggest that when you look at the total record, he did consider all of the facts that were connected with the non-use itself, weighed those factors, took that into consideration and make his determination. And I would suggest that, as the finder of fact, unless this court finds it clearly erroneous, that that his findings of fact need to be upheld. So I would suggest that, and I think my time is just about up, if anybody has any questions.
It was as close to perfect ending of an argument. I'm the clock keeper. So thank you. It was argued exceptionally well and briefed on both sides, and the matter is taken under advisement.
Thank you, Your Honors.
And our last case for today's sitting is 25P 0277 JW versus TS as the parties are setting up. I just want to remind the parties that this is a partially impounded matter. And so, Attorney Weber, whenever you're ready.
Thank you. Good afternoon to Your Honors. Philip Weber.
Just going to start the time. Okay.
Sorry. Representing the defendant appellant, Mr. T.S. Now, this appeal is here today because there were a few different issues in regards to the harassment prevention order. I would begin with the fact that the conduct that was shown at the hearing, it wasn't actually malicious. Now, certainly understandable that Mr. T.S.'s conduct could be seen as to be perhaps maybe distasteful. He maybe people wouldn't like the way he conducts himself, but that's not the question. The question is whether it was malicious, whether it was the intent was there to be cruelty or hostility in regards to it, and that wasn't the intention. Throughout all the proceedings, T.S. was very clear that his intention was political. It was that he did not like the way that JW was involved in local town issues and didn't like the things that she was trying to introduce into the town, and that is what he was responding to. Now, the way he responds, he even admitted himself, saying that he can be a bit animated in the way he does things. So it's certainly understandable that JW may have not liked the way he did what he did, but that's not enough. That's not what we are here in order to review. The question is whether it was enough to justify a harassment prevention order. And indeed, JW admitted during the hearing that there was no direct kinds of threats of any kind. So there's no question that he never said anything, no question in regards to the fact that he never said anything to her that would be considered a direct threat. So we have to take what is there, what he did. And what he did was just an animated person who maybe a little more animated than most people would like, but again, that really wasn't the issue. And it's not just the manner of his conduct in general, but there's also the specific fact that we were lacking 3 specific instances. And indeed, through their opposition brief, the plaintiff admits that the court never actually specifically identified 3 instances. Even if we look, they talk about the totality of the circumstances, but as Your Honors are aware, it's not really the totality of the circumstances unless we have 3 instances. There have to be 3 identifiable instances. Now, if we were to look at this, we have one instance in which he parked in front of her home. Now, our position is that none of the instances would be justifiable, but I refer to that one because there was a lot of time at the hearing spent in regards to that. Even if parking in front of her home could be considered, that would be one. There was an instance where he's alleged to have said, and pardon my language, but I'm referring to that she smells like shit, which, again, I would argue that that's not something that is done.
As she walked by with her baby in her stroller, right? I mean, that's right. That was that incident, right?
Yes, right. I believe
so that adds a little flavor to the.
As I stated, the way he conducts himself, it could certainly be seen as distasteful.
Yeah.
I'm not going to say distasteful. Certainly could be a characterization of it, but distasteful, I think, is different from the idea of that it was malicious to the point of justifying a harassment prevention order. But even if we were to take that as a second one, which again, my position would be that it doesn't justify it, but even if we were, that would be 2, and then where would be the third? There talks about different instances of interaction they had because they had a variety of interactions over their time. The third, there was a podcast at one point, but a podcast where he did talk about her, but for one thing, the podcast isn't a direct communication with her, it's a podcast. And in the podcast, he talks about her. He talks about things that he doesn't like about her in regards to these issues. I don't see how that is actually the instance, and we have the problem as well that the court never even said, well, this is the third instance, because then we could be talking about it, but the court actually didn't even identify 3 instances. So we don't have the 3 instances that are indeed necessary for the harassment prevention order, and even the instances that we do have are instances where, again, distasteful, certainly, maybe a bit more animated, but this is an individual who, he cares about his town, he cares about the way it's implemented, and he was trying to communicate with her in regards to it, and communicate with the community in general in regards to it. His intention was how the town is operated, whether or not certain different policies get implemented, and whether or not his positions on it are right or wrong is, beyond the point. He has a position on what he feels the town should be like. She has a position on what the town should feel like. Clearly, they do not agree in that regard. Fine, so be it. That is part of political discourse. And even if his political discourse could be seen as being less than likable, it's still just that, political discourse. Everything that happened in regards to it, it was always about the town. Even when he would do things, he would post, at one point he had a picture about her with her child when the child didn't have the appropriate bike gear, and the point of that was that she wanted to implement different bike paths, so it is always connected to the town issues that were in place. The idea was, oh look, this is a person who doesn't even follow regulations on one type of bike issue but wants to put different ones into place. But again, it comes back to the town issues.
Even if it's political discourse, there's a limit. The First Amendment doesn't protect, and there are exceptions, right? Fighting words and truth threats. And so it doesn't give him just carte blanche authority because he's fighting against bike lanes or he cares about his community.
There is a limit, Your Honor. Certainly, of course. It is not without limit. That is true.
And this is not all connected. In other words, parking your truck in front of her home, right directly in front of her home, arguably could be considered to be harassing type of behavior, to try to send a message of, I know where you live and I'm here watching you, right? You disagree that it hits the limit, but it's not connected with political discourse. This is not in the sense of we're arguing passionately but disrespectfully. And the second, I'm not sure how I connect political discourse with the comments and the rude and offensive comments of what she smells like in front of her baby. Again, I think there could be an argument to be made that the continual directed and targeted offensive comments to her were caused with an intention to threaten her. And she certainly felt threatened, right, by his behavior.
She testified that she felt threatened, and that one, I don't focus on that one as much in my brief because it does feel as though that was her testimony.
So the judge doesn't have to specifically articulate, the case law is clear, every single incident, if we can review it and say that we find 3, right?
If the court could find 3 instances, that would be correct, Your Honor. If the court would find 3 instances, but I would argue that even now, as Your Honor talked about it, and I do apologize, the parking one was not a political motivation. That is correct. The record does talk about he was going to a Bible study. It was nearby. He talks about not having a good place to park and looking around for a while, and then he parked there. Now, and he admits himself, should have found a different place to park. So, and one of the reasons I refer to that one is of all the actions that are referred to, that one, while I do hold my position, would probably be the closest, at least, to being something that would qualify for a harassment prevention order, at least of the actions. But again, then that goes back to the fact that even if we credit that that's one instance, and we would need to be able to articulate 3 instances. The one in regards to what she smells like, it was, if I recall correctly, outside of kind of town hall on a day in which voting was taking place. He was, again, more animated than a person perhaps should be.
But that doesn't necessarily connect to the freedom of speech, right? So in political discourse.
Well, and even if Your Honor would find that would get us to a second instance, and we would still have the issue of a lack of a third instance, because every other instance talked about was him referring to, this is a person who's trying to implement different policies in a town. These are bad for the town, and him talking about, his issues in regards to that. I mean, even with the podcast, that was the purpose of it.
And so the judge does have the ability, wouldn't you agree, to take context into consideration. certainly there needs to be 3 instances. But in other words, when someone says, oh, we're going to expose you and we're going to do this and we're going to do that, I mean, context does matter. And here, through a FOIA request, she finds out that allegedly your client has made some pretty scary and concerning statements to other people, and there's other behavior. So it's not like in a vacuum. If someone says, hey, you're going to be exposed, a stranger in the street, you walk by and you don't think twice. But somebody with a, how many years, 5, 6 year history of continually needling and offensive and really troublesome behavior, when they hear, everybody listen, we're gonna expose, and we're gonna do this, and we're gonna do that, they might have a different context when you know that this person allegedly called somebody a Nazi and allegedly said, well, that's why I carry a gun or I have a license to carry, etc. I mean, those things shouldn't be taken into consideration for the third act?
Well, I would argue that when it comes to a third act, the third act does need to be a specific instance as opposed to just a general idea of a totality of circumstances.
Agreed.
And Your Honor's point is certainly correct that you have to consider everything. Nothing is in a vacuum. That is correct. But even Your Honor yourself said that she would hear about things that he was saying to other people, because the intent is on both ends. It's the idea of what both sides were intending. That what does she feel as though she's feeling, but what is he intending? If he's speaking to someone else about her, there's even a question of, did he even intend for her to specifically hear that? Is he trying to communicate to her, or is he someone who is talking to someone else?
No, I would disagree. Someone says, you better watch out, and then I find out that the person who said, you better watch out, took a gun to 5 other people and put it to their head the next time after they said, you better watch out. I think that qualifies, right?
Well, I would suppose it would depend.
That one isn't exactly directed. It's in context of what this person's behavior means.
In the context of what the person's behaviors means, it's one thing to consider who they are, because it seems to be if I'm understanding Your Honor correctly, it's consideration of who this person is as a general person. And I think there is, at least it can be problematic in regards to, well, she heard about something, because one point, part of the hearing
It's a true threat, right? It's a threat.
Well, there was no, I mean, she herself said that during the hearing that she was never directly threatened by him, or even with words either. I mean, that that there was no direct threats to her with words either. Obviously, if there was a physical action,
Right.
would be a whole nother story.
So the podcast, for example, of, you're going to be exposed and we're going to, everybody listen and I'm encouraging you to follow and all the rest in context, my point being, is that
but I would argue,
you rise to the level of a true threat.
I would argue that saying that someone's going to be exposed is not a threat. That is, it is the level of discord saying, it's the idea of it is saying, you are someone who is not true to what you say you are. I'm going to show that, you are a duplicitous type of person. Whether or not she is or not a duplicitous person is really beyond the point, but that's the intent. I'm going to show the people of this town the type of person you are, so they know that the type of things that you're proposing for this town shouldn't be in place. They should know the type of person, the type of character you are. Because again, intent is what it goes back to. The intent here is not to try to put this cruelty towards her. The intent is, I want the town to know what kind of person you are so they know not to support the types of things you're putting into place for this town. The intent that he has is indeed quite significant in regards to this, and that would be what I argue, that the way he goes about it, certainly not very delicate, it's certainly not very light. Obviously, he's very heavy-handed in the way he does things, but being heavy-handed doesn't change the intent behind what it is that he does. And just because I want to make sure to address at least briefly my other points is that even if Your Honors would find that this order should be in place, it should never have been a 2-year order. The court was very clear that this was an initial order. They had a type of...
A mediation, right? There was a mediation the year before the hearing in which the plaintiff had gone to court initially to file for a petition for harassment order, and then they ended up being agreeing to mediation, and they came up with an agreement, right? And then a year goes by, and actually this only comes to be when your client goes back into court, right, and says, hey, there's no definitive time period here. And then all of a sudden there's a hearing, and then that's when the order gets issued, right?
Correct, Your Honor. Because the court even said that, the initial mediation agreement, it was mistakenly done. I forget the exact wording. I think it was even saying that they messed up, something along those lines. I do have the language in my brief, saying that because the mediation agreement needed an end date. It wasn't designed, it wasn't supposed to be some indefinite agreement, but even more importantly, it was a mediation agreement. It wasn't a harassment prevention order, and the court was very clear in its language that they were treating this as an initial order.
Well, the judge at the second hearing characterizes the agreement as an order, right? She says, it was an order. I assume, first of all, is that correct? And second of all, do you agree with it or disagree with it, that it was an order?
Well, the judge referred to the mediation agreement as a type of order, but never a harassment prevention order. It was a different type of mediation agreement in place. And if
do you have a position as to whether the mediation agreement was or was not an order?
I think it was. I think it was a problematic mediation agreement because it had no end date. It didn't seem to have any recourse for what happened if anything was violated. I mean,
I don't know why you could just say it wasn't an order.
It was not an order. I think there were problems with the order, no matter how you put it.
I mean, it wasn't an order.
Because it was a very problematic order. But regardless, and if we were talking about a renewal, then we wouldn't suddenly be considering. I mean, we were considering is the way the hearing was conducted. It was very clearly shown we're considering everything, not what has happened since this order took place, to see if it still needs to be in place and still needs to be extended, as would happen in an actual renewal hearing. This was treated as, okay, let's go back to the very, very beginning so we can look at everything, see if an order needs to be in place. And if that's the situation, and if the finding is that an order needs to be in place, well, the law is very clear that it would be a one-year order. Seeing my time and the rest of my brief. Thank you.
Attorney LaMattina.
Thank you, and good afternoon, and may it please the court, Liana LaMattina for JW. On January 28th of 2025, TS initiated further proceedings in the Boston Municipal Court East Boston Division by filing...
I'm just going to interrupt you and just sort of pick up where we left off. Did the judge have the authority to issue this 2-year order?
Yes, the judge did.
How? Because there was no initial order, correct? Like there was the mediation agreement.
It was adopted as a court order after a colloquy. And then...
But not a harassment order, though. There was actually no order. The defendant wasn't served with an actual harassment order the year before, right? So it was not a harassment prevention order.
It was not a harassment prevention order in the sense of, as you described, Your Honor.
It wasn't, right.
Right, correct. However, it was the adjudication of a complaint for harassment prevention through alternative dispute resolution and a court order with no contact. It even defined indirect and direct contact.
What does that mean, though? Like, what is that when you're saying when the court adopted the order? What happened was, tell me if I'm wrong, they came in the year before and agreed to the mediation, like I said before, and then a signed agreement was placed in the court file, and the order never issued.
An order did issue, though,
not a harassment prevention order never
Correct.
issued. And so the statute, 258E, deals with the issuance of a harassment prevention order, right? And states that it can be issued for 1 year, extended for 1 year, correct?
Yes, that's what the statute says.
So how do we get to tack on the year of the, I know you're saying, well, there was a mediation agreement and it got adopted as an order. Like, that doesn't make sense to me as how that can justify us extending an order for another year, an HPO order.
Right, so pursuant to the Uniform Rules of Alternative Dispute Resolution, mediation is permitted as a means of adjudicating a harassment prevention order.
Okay.
When we started the proceedings that day, the court announced that she was treating this no contact order mediation agreement as a 1-year harassment prevention order, and that extension that JW was requesting would require a 2-party hearing.
What legal authority did the judge have to do that, though, just to convert a mediation agreement into an order? a harassment prevention order.
This is certainly uncharted territory, Your Honor, because I looked for cases that would have a similar situation and set of facts, and I was unable to find that.
So for a moment, let me suggest that if we disagree with your position, that the judge had the authority to issue a 2-year order, because in essence, that hearing that was held was the initial order, and the law, again, you can disagree, but assume that we decide that the law is clear that at the initial order, it's 1 year. Okay. So what's your best argument that there was evidence of 3 separate and distinct acts by TS of harassment?
Absolutely. So,
can I just say, can you just look at Record Appendix 117? The judge says, I think I can find 2, in essence, is what she says. And so, and she specifically designates the October 23rd and then the event in 23. So I'm assuming, and I want to hear from you, that the October 23rd is parking of the car, that the 23 event is the smells like comment. If we were to agree that those would qualify as separate acts, where's the third?
well, the court heard ample evidence of multiple, and I'll give you the third right now. I would state that the January 16, 2024 Winter Votes podcast, where he dedicated an entire portion of the podcast to going after and exposing JW, encouraging listeners to message JW, and alerted that listeners that there would be a part 2 of the Jeweler Waller's tapes or files. And he refers to himself as a difficulty. And Your Honor talked about context.
Right.
Context is very important.
Is it a true threat or is it fighting words?
I would say it's under the true threat doctrine, because it's not direct threats of imminent physical harm, but words or action that, taking into account the context in which they arise. Now, you have to understand, in January of 2024, there had been multiple years of posts on the Winthrop Votes Facebook group, which is a group that he monitors and controls the content, right?
And they're political in nature, though, right?
They start off political in nature, but here's the thing with TS. He actually doesn't talk about the political issue. In his eyes, he is so fixated on JW that the issue and JW become one in the same, that he is the conduit, not just for his anger and frustration at whatever the political issue may be, but that for others to make comments. So for example, the Streets for Babies photo, right? He might start initially appearing to talk about bike lanes, but the comment that he makes is about her and her putting her child there. And then if you look at the other comments to it, it's people commenting on her. Why haven't her in-laws stopped her? Who does she think she is?
Does that qualify as an act of harassment?
When it happens on a repeated basis. And remember, if you look at case law, it's the entire course of harassment rather than each individual act that must cause fear or intimidation. O'Brien versus Borowski, 461 Mass 415. And so if you're talking about a multi-year period with that context of having repeatedly, no, she knows that in his mind, she is subhuman, a carbon unit. She's not human at all. His words when describing her, she knows he's threatened his LTC against people and utilized physical violence against people when he escalates. For some reason, she is the fixation of his political anger, even on issues that she's not a part of.
Even if we agree with you in context, there still needs to be 3 separate and distinct acts, right? So yes, context matters, I agree, and there's a long history here. But by, in a podcast saying, she's going to be exposed, and we're going to find out the truth, and who's lying, and who's telling the truth, and that type of rhetoric, it still has to rise to the level of a true threat, correct?
Yes.
Okay, so I'm not sure, and explain to me, and do you have any other instances in which you think the record supports a separate, if we were to not agree that saying in a podcast, she's going to be exposed and the truth will be told and we're going to continue this highlight?
Yes. In an email about traffic data, he responds to her, I am never the instigator, I only respond. You want to attack my email to your traffic czar and expect me not to react. Go fuck yourself. You don't feel safe. I don't give a rat's ass. I hope it motivates you to leave Winthrop.
Okay, so
That
how is
sets
that?
the tone.
No, that's
there.
tone, but we need true threat.
That
right?
is a threat. He wants her to leave. That's his intent right there. He's trying to get her to leave. He's trying to get her to feel unsafe. He's acknowledging the fact that he makes her feel unsafe.
He wants her to move, but it's a offensive way of communicating, and it's certainly, I would go further than saying distasteful, but how is it any different than, I want you not to vote for bike lanes, or I hope you move to some other place? It's not a threat of harm, it's not a threat of violence, it's his hope that she just leaves Winthrop. Isn't he entitled to express that opinion that he hopes she doesn't live there anymore, even if she doesn't feel comfortable? He doesn't care. He wants her to go.
But
doesn't he have the right to say that under the First Amendment?
Under the true threat doctrine, though, it doesn't require an explicit statement of harm as long as the circumstances support the victim's fearful and apprehensive response.
Sure, and there are a number of cases in published and unpublished with social media being ever present, in which there are instances, in one case in where there are like two wolves running, and the message underneath is that I'm coming to get you. And that indirect threat could be interpreted as true threats to do harm. But here, in a podcast about politics, when he says, the truth is going to be told and she's going to be exposed, or an email that says, I don't care how you feel, I hope you move. I'm not sure it gets the level of a true threat. That's an exception, right? Because you have the burden of proving these three separate and distinct acts.
But in the entire context of it, though all of those acts even are separate and distinct, and in the full context of this pattern of harassment, then yes, there are, and all of those acts, because you know the malicious intent behind it, which started in 2019 with, I don't care that you don't feel safe, I hope you leave Winthrop. That is the intent. That's the malicious intent behind this conduct. And this court, I would point to COMMONWEALTH versus Johnson, 470 Mass 300. That's a 2014 case. That's a case where the defendants utilized false Craigslist postings to incite others to call the victims. And the court held that that speech was integral to criminal conduct, serving only to implement the defendant's purpose to harass and cause substantial emotional distress to the victim. So when TS is making these posts, right, and on Winthrop Votes, for example, he does one about a large residential development, a town loaded with JWs, we can change the course. JW had nothing to do with that development at all. She's not a party to it. And then when he explains to the court, he means folks that want multi-unit housing, who want more buses and bike lanes, but the comments on that are attacking JW. The conversation isn't about multi-unit homes. He's not talking about multi-unit homes. He's talking about JW. And then the anger and frustration of people in the community turns towards JW. Now, JW has to go out in the town of Winthrop, walk around her community, go to the grocery store, pick her kid up from school, go to community meetings, understanding that the people around her have been attacking her on social media, and the conduit for that is TS. And so if you also, this court in Lucy v. Kinnan, 24P968, it was decided on December 15th of last year. Kinnan's comment, it talked about the distinction, because that was on a Malden Facebook group page. And what started as an original post about politics, Kinnan replied and made a personal insult to the poster, right? And the court held that there was a distinction between that politically protected speech, talking about a public meeting and encouraging folks to attend, and then the insults that occur after. And although that was talking about the anti-SLAPP statute, but I think it's important to point out that that it is harassment when TS is utilizing a platform not just to specifically target JW himself, but also to incite and encourage others to personally attack JW. That is intimidation, that is fear for JW in the full context of years of incessant contact, telling him to stop contacting you, not to talk about her, blocking her, being referred to as a carbon unit and subhuman. All of these instances that were heard before the court become specific instances of harassment, because when you also take a step back and look at the larger context, you see the malicious and cruel and hostile intent behind it. And I would just, to wrap up, as I have a few more seconds here, the lower court explained how she would proceed, holding a hearing on the extension of a harassment prevention order, and TS did not object to proceeding in that way. He just didn't like the outcome of the hearing. He agreed to the process to get out of having to comply with the no contact order imposed by the court. And I would also state that it's important for this court to acknowledge his demeanor multiple times in that hearing where he was laughing at the presentation of evidence. The court noted that. Additionally, harassment prevention orders exist for a reason, that there are people like JW living in fear and in need of protection, and my client continues to live in fear of this man to this day. And so for these reasons, the court should affirm the lower court's decisions. Thank you.
Thank you. We'll take the matter under advisement. That closes our hearings for today. I want to thank our excellent timekeeper, our court officers.
Thank you.
Hearings are adjourned.
Court stands